Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to today's sitting of the Appeals Court. I'll begin by introducing the panel. To my right is Justice Sabita Singh. To my left is Justice Rachel Hirschfang, and my name is Ariane Vuno. I always like to remind everybody before we start that the panel has read everything that you have provided to us. We know the case fairly well, we hope. We know the facts for sure. And so you can get right to your points when you begin your argument. Each side has 15 minutes, so I think everybody in this courtroom knows, and there is no rebuttal in this. Our rules don't provide for rebuttal with respect to oral argument. The first case is Commonwealth versus Cesar Valentin, 2024-0216. I see the parties are already here. Counselor, good morning.
Good morning, Your Honors. May it please the Court, Daniel DiMaria appearing for Cesar Valentin. I will begin with the second issue in my brief this morning. My argument is simple, and it's based on the Mahoney case. Videotapes are admissible if they provide a fair representation of what they purport to depict. In this case, Deputy McGuire testified that the video was a fair and accurate representation of him going up the stairs. That is the only portion he authenticated. He did not authenticate the portion depicting the altercation. Then later he's asked whether or not the video depicts a fair and accurate representation of what the floor looked like after the incident. So he authenticates the first part and the last part. He does not authenticate the middle part.
And so what's the concern? Could you just articulate, like, is the notion that the Commonwealth would have somehow spliced out the middle of the video, or is your position that it's required that someone authenticate every second of a video?
So I can't imagine they would have spliced anything out. I don't know if there's any sort of computer error, any sort of, irregularity with the video. I do think in each and every case, there's three ways of authenticating. One is whether the entire video is a fair and accurate depiction. In this case, the video was only 8 minutes long, and it is unfortunate that the prosecutor did not ask him, did you watch the whole video? Now, what makes this case very unique as well is that Deputy McGuire basically gives a play-by-play video. It could have been any one of us sitting there and just basically saying, hey, this is what I see on the screen. If we look at page 99 of the transcript, for example, when the video's playing, he says, so it looks like I was just going up to do the second half of the security rounds. So it looks like. So again, he's just giving a play-by-play. This has not been authenticated.
But didn't he previously testify as to what he saw?
He did not testify, Your Honor, until the video started playing. The only portion he testified to was him going up the stairs. That is it. The record is very clear on that.
So I guess there are kind of two things going on, I think, in your argument, and I'm just trying to untangle them for myself. I think one strand of your argument is that the witness was not actually a percipient witness to the things shown on the video. Is that part of your argument?
I think he was a percipient witness, Your Honor. He missed the first part of it as he's going up the stairs, but once he hears the scream, he runs down, and he would have witnessed the majority of it. But okay. We don't know that because he didn't testify to that.
But isn't he on the video?
He is, and this is one reason why this case is distinguishable from the P2 Yang case. In that case, the witness was specifically asked, are all four of you on this video? And the witness said, yes, we are. That depicts all four of us. It shows exactly what happened. Here, he's never asked, does this video show exactly what happened? Nor is he asked, is that what took place? He's simply viewing the video and giving a play-by-play like a sports commentator would, calling a game.
A wrestling match.
Exactly. I was going to say Patriots game, but any sort of sporting event.
I still don't quite understand the answer if you actually gave a full answer to Justice Hirschfang's first question, which is, where's the prejudice here? What difference does it really make with respect to the evidence in the case?
So that's a good question, Your Honor, and the entire case rests on the video. I think if there had been no video, there would not have been a conviction.
But the video would have been authenticated had these, I think even you say that certain questions needed to be asked in order to authenticate it. Do I understand that correctly?
Yes, Your Honor. So going back to your first question, without the video, I don't think there could have been a conviction given that the victim did not testify. As to your second point...
Well, there was other evidence with respect to the altercation, right?
Because it was just a play-by-play of the video, the only evidence would have really been that there was blood on the floor and the person had been injured and the bookshelf was dislodged. But none of that links up to an assault. The lieutenant, I believe Carol was her name, she did not witness any of the incident. And so we really are left, if the court were to exclude this video, there really would be no evidence. And we cannot assume that Deputy McGuire would have said, yes, it is a fair and accurate representation. We simply don't know. And there is a very troubling quote by defense counsel at page 100 of the transcript. And defense counsel actually says, I've never seen the video. So if he hasn't seen it, maybe Deputy McGuire has not seen it. Now, to be perfectly candid, I believe defense counsel saw a different version from a different angle, but it is very troubling. And I will note as well the realities of video, as I'm sure the court has encountered. A lot of times you need to have special software. It's difficult to work with. It might work with PC, not for Mac, and so on and so forth. So we cannot assume that Deputy McGuire actually saw the video.
But he saw the fight.
Yes, Your Honor, but he never testified as to what he saw. He was simply narrating what the video displayed. If he had said, this is what happened, then they played the video, I suppose the court could say, well, it's been corroborated. The video matches with his testimony, but that did not happen here.
Well, I mean, I do see, and this is, I'm on the fly here, but page 101 to 102 of the transcript, Deputy McGuire is asked, can you describe just what this area looked like after you and other officers responded? What do you think you saw? And he says there was a big puddle of blood on the ground from Matos Figueroa bleeding, and there were books on the ground. Figueroa's shoes were on the ground. Did you notice when you detained Mr. Valentin, was he bleeding? Did he have any injuries or anything like that? No. Prior to this clip, throughout the night, did you observe Mr. Matos do anything or say anything to Mr. Valentin? No. So, I mean, he does testify, the deputy does testify in addition to narrating the video about what he saw.
Right, I'm not disputing that there was evidence of the blood on the ground and the bookshelf or the books on the ground, but that still does not show assault. The whole portion, from my reading of the transcript about the altercation, was him narrating it as that quote I gave you from page 99, so it looks like I was just...
Can you look at page 93?
93?
Okay, so this is prior to the video?
Page 93, Your Honor.
Right? I saw the defendant punching the detainee.
Continuously.
At the very top.
Yes, I see that, Your Honor.
So that's reflecting a direct observation, correct? Not narrating the video?
I believe on the fly you are correct, Your Honor. I still do not respectfully think it changes my argument as to the fact the video was not authenticated and it was the most damning evidence against Mr. Valentin.
Okay, so, but given this testimony, I saw the defendant punching the detainee on the phone continuously. The guy on the phone fell down. He was bleeding on the ground, being punched, kicked. That was picked up by the defendant, thrown onto the victim. So you're saying that the video still would have been critical?
I still think that without the video, the jury would have had a very, very difficult time with Mr. Matos Figueroa not having been there. And as they say, Your Honor, a picture's worth 1,000 words, and so the video is just so damning compared to the testimony.
So does that take you to your first argument about the missing witness instruction?
It does, Your Honor. So it takes me there exactly. And with respect to my missing witness argument, I do want to, and I had not realized this at first till I prepared for oral argument, but at page 15 of the Commonwealth's brief, they make a very troubling statement. They say, and I'll quote it, and that's at page 15, as discussed outside the purview of the jury, the Commonwealth was well aware that the victim's testimony would implicate his relationship with the defendant and that any testimony he provided would be likely to introduce improper and prejudicial evidence of motive. Is the Commonwealth really, really saying that they will not call in a witness because that witness has exculpatory evidence about an incident? That's a very slippery slope, and the court should be very uneasy when it comes across a statement.
Well, I'm not sure that it is fair to equate improper and prejudicial evidence with exculpatory evidence. Obviously, some exculpatory evidence would be improper and prejudicial, but there are many other types of improper and prejudicial evidence that may not be exculpatory. They may serve only to inflame the passions of the jury and not to tend to prove an issue that is an evidence in the case. And the way I read that after I read Salatino was that the Commonwealth was making a discretionary decision not to call, or a tactical decision not to call the victim, which under Salatino, the Commonwealth seems entitled to do.
I will address that in a moment, Your Honor, but I just want to emphasize, though, how troubling that was to me. And I do want to note that at page 143, it seems like defense counsel has no idea why the witness is not here and says, if they were here, I could ask them about it. So it really should
Did defense counsel seek to summons the witness?
He did not, Your Honor, and again, that comes down to the realities of being a defense lawyer. Getting someone who's facing murder charges brought into court is not an easy thing. I know.
No, you just file a motion for a subpoena. You can do that. Had he wanted that, had defense counsel wanted that person to testify, that could have happened.
From experience, Your Honor, it's never that simple as a defense counsel. You have so much difficulties bringing in an inmate to court. But coming full circle to the Justice's question, in Anderson, for example, which I guess is what the Commonwealth's argument is based on in terms of the missing witness instruction not being proper, there is a big difference in that Matos Figueroa was awaiting trial, whereas Jenkins, the victim in the Anderson case, had already been convicted, and so he could have been impeached with his murder conviction, whereas in our case, it would have been inadmissible since he'd been charged but not convicted. And I would also say that the case against Mr. Valentin was not so strong to absolve the Commonwealth from calling Mr. Matos Figueroa, because we don't know what was said or done or what took place between the defendant and the victim. It appears there must have been some sort of provocation for him to go off the rails like that.
If we are not persuaded by your argument that the video was improperly introduced, can you still make this argument about the missing witness? In other words, you just said the case was not so strong, but with the video, it's a pretty strong case. Are you?
The only issue, Your Honor, is as Deputy McGuire testified, the video does not show any interactions that took place between the two earlier in the day or the day before.
Right, but the Commonwealth need not prove motive. And the video shows a brutal attack. Whether or not it was provoked is not on the video, but the attack is on the video.
That is correct, Your Honor. And on that point as well, Your Honor, another way to look at it is the jury may have inferred during deliberations, hey, Matros Figueroa is not here because he's scared of Mr. Valentin, because he's been threatened by Mr. Valentin. So the jury may have used his absence against Mr. Valentin in an unfair and prejudicial way. And Your Honors, if there are no other questions, this concludes my submissions.
Okay, I'll check with the panel. No further questions. Thank you very much.
Good morning, Your Honors. May it please the Court, Lindsay Conkey with ADA Darcy Jordan, supervising for the Commonwealth. This Court should affirm the defendant's convictions because there was no foundation for the judge to give a missing witness instruction, and because trial counsel choosing not to object to the authentication of the video did not amount to ineffective assistance of counsel. I'll start first with the missing witness instruction. As outlined in the brief, under Williams, there are at least 5 factors that a judge can weigh when deciding to give the missing witness instruction. And here, the judge did not abuse his discretion when he denied it, because in his oral findings, he found that the Commonwealth had a strong case without the victim, who would be considered a hostile witness if called by the Commonwealth, as he was at the time awaiting trial in Suffolk County. So that the Commonwealth had a strong case without the victim's testimony supports factor 3, that the purported testimony could be produced from other sources. That the victim would be considered a hostile witness supports factor 2, that the party expected to be called had the party expected to call the witness had a plausible reason for not doing so. And lastly, even though the judge didn't explicitly credit these factors in his findings, the court can affirm on the alternative where the record supports it, that the witness was also equally available to either party, given he was currently incarcerated, or factor 4, and that the live testimony of the victim is less important where there is other independent and reliable evidence of the crime, or factor 5. So of those 5 factors outlined, I think there is strong support for 4 of them, for why the Commonwealth did not need to call the victim.
Say to the argument that what's missing from this case is what happened before that altercation.
Well, as Justice Hirschfang said, we don't need to prove motive, and there's no obligation for the Commonwealth to help support the defendant's argument for self-defense.
So are you saying that the defendant would have had a greater incentive to call that witness?
Correct. If there's no other questions about that issue, I can move on to the video.
Mm-hmm.
Okay. So trial counsel did not provide ineffective assistance of counsel where he did not object to the surveillance video because it was properly authenticated. Deputy McGuire was an eyewitness. He testified that the footage was a fair and accurate representation of what occurred in the unit that evening. And it seems that the defendant is claiming that the authentication doesn't extend unless the individual authenticating it pauses it at every frame and says, yes, that's still me, yes, that's still me. But simply that's not how authentication works, both under case law and under the rules of evidence.
Well, was the witness specifically asked whether he had viewed the entire video in order to authenticate the entire video?
And I don't believe that he was asked directly to authenticate the entire video. He was shown a still image and he identified himself, and then they played the snippet and he identified that that was him as well. And then they did the play-by-play. But I'm not sure that he was ever said the words explicitly, I authenticate this entire video.
Is that problematic for you?
No, because I can't find any case law in which you need to have watched the entire video and, as I said, pause it frame by frame and say that's still me. So barring any evidence of tampering, no, I don't think that that is problematic.
Would you agree that the better course of action would be to have asked whether or not the entire video was reviewed and have an authentication of the entire exhibit?
Potentially, however, I don't think that case law supports that that needs to be done in order to authenticate the whole video, so I don't think that it was a failure on the part of either counsel not to have.
How about the statement that defense counsel brought to the attention of everyone here today, the statement by the defense lawyer that he had not actually viewed the video? Is that something that should weigh in the ineffective assistance calculus?
So my understanding was that it's not that he hadn't watched the video, it's that when he had watched it, it was from a different angle. I believe he called it a fish lens angle, so he hadn't seen this new angle. It's not that he hadn't seen the video, he just wasn't aware of the orientation of it. And I personally have seen both videos, so I understand what he's talking about with the fish angle, but I'm not sure if there's a more formal name for it, so.
Fisheye lens, I think, maybe?
Yeah.
It's that weird stretchy thing.
Exactly, yes.
Okay.
I would add that the claim can't prevail if counsel realized that the objection shouldn't be made and didn't make it. There's no obligation to make a futile attempt to object to the video. And as I stated, I think that the video was properly authenticated.
Okay. I'll see if the panel has any additional questions.
Okay.
I see none.
The Commonwealth rests on its brief. Thank you.
Thank you both very much for your arguments. We'll get back to you, take the case under advisement and get back to you. The next case is Commonwealth versus a juvenile, 2023-1302. Remind the parties that this case is impounded. Good morning.
Good morning, and may it please the court. Caroline Alpert for the juvenile who is present here today with his father. To justify a pat frisk, officers must have reasonable suspicion that a person is armed and dangerous. The circumstances here, even in totality, fell well below that standard. Officers observed two passengers on a moped without helmets, justifying a traffic stop, but not more than that. This occurred at 9:40 a.m. in the morning in broad daylight. The moped was not speeding or driving erratically. There was no report of any crime, let alone anything involving a weapon. When Trooper Walczak confronted the juvenile, he was not agitated or threatening. He did not try to flee. He was not a known violent gang member or as having recent firearms offenses. He did not have an awkward gait, his hands in his pocket, or a visible heavy bulge. So Trooper Walczak talks a lot about the fact that he was turning his body away. And I would start by saying that if your honors have not seen the video that was submitted, when you do watch...
We've seen the video.
Great, thank you. When I watch the video, I truly don't see this turning of the body. The time that I see him turning his body is when...
But that doesn't really matter, does it? Because the judge saw the video, and the judge decided that subtle, but that there was a turning of slight turning of the juvenile's back away from, so to speak, the officer. So although we can see the video ourselves and we can look at documentary evidence and draw our own conclusions, what do we do with the fact that the motion judge here made a specific finding with respect to that?
I don't think that matters because what Novo says is that when your honors have the video yourself, there's no reason to give deference to the judge below. And so I think what your honors need to do is watch it and make your own determination about what you view in the video. I think what is seen is that when he does really visibly turn his body, it's because Trooper Walczak is grabbing his hand, pulling it behind his back. And that's apparent when you watch the video, the De Silva video from the other angle, that's what's happening there. If anything, if there are any slight movements, I think there's a very simple explanation for that, which is that Walzak gets out of the car and is standing to one side of him. He has another trooper confronting and handcuffing his friend in another direction, probation officer another direction, and then you can see in the frame that there's multiple other troopers showing up. So if there's very slight looking around with his head, I think that's the simple explanation. And our cases that talk about looking at body movement and using that to determine whether there's reasonable suspicion that someone is armed and dangerous are cases where we're seeing something that's very unusual. So for example, in DePisa, we have someone walking with a straight arm gait. That's a really odd way to just walk. Similarly, in Karen K, we have the officer testifying that the juvenile is constantly changing direction, turning back in this strange way, angling her body, continuously adjusting her waistband while she's doing that. So these are really noticeable and unusual behaviors, which I don't think we see in this video. And I also think what we're missing in this case is explanation from Walzak about his training and why this particular movement would indicate that someone is concealing a weapon. And so in Karen K, what the court really focuses on is they say it's a close call, but the plus factor, the thing that gets it over the edge is, quote, precisely the very extensive testimony from the officer there about his ATF training, what he's learned there, and why what he's seeing here is connected to that training. We don't have that at all here. What we have is in the introduction of Walzak when he's kind of saying how long he's been an officer and listing his trainings. He includes there in his list that he's attended characteristics of an armed gunman. But that's the last mention of it. There's no discussion whatsoever about what he's learned there and a connection between that and what he's seeing here.
What about the fact that there was also no response to the question, do you have any weapons?
Sure, and so I think
Of course, knowing the fact that the case law says there's no obligation to, and our Constitution says there's no obligation to answer a question posed by police officers, but how does that factor into the scenario here?
So I think here, again, it really doesn't factor in. And when we look at Commonwealth versus Martin, and then also layer Commonwealth versus Warren, which came after that on top of that, what the proposition those cases really stand for is that if citizens have the right to not be obliged to answer questions, then we need to honor that right, and citizens aren't obliged to answer questions. And I think an important fact here, too, is what we see in the video is a teenager who I think appears like stunned by this response that he's not even sure what's going on. He gets off the moped, immediately gets asked, do you have a weapon? And 7 seconds after that question is when the pat frisk begins. So he barely even really has an opportunity to answer. Perhaps he's thinking about how he wants to answer. I think the other important thing that's really evidenced in this case is, meanwhile, his friend, who is asked the same question, got any weapons? He says no, and he gets pat frisked anyway. And so if we're going to allow a non-answer to lead to a pat frisk, then what we have is really a trap that as soon as an officer asks you, got any weapons, if you say yes, no, or don't answer, all of that is leading to a pat frisk. And I think Warren and Martin very clearly say that that cannot be the case. The other factor that Walzak and the judge focus on is his clothing. So the fact that he's wearing long sleeves and long pants. And there's very limited case law on clothing, and I think probably for good reason, and I note this in my brief, I think there's a lot of really legitimate explanations for people's clothing choices: religion, culture, body image, profession. I mean, lawyers wear suits to work year-round. And the two cases that we have in Massachusetts that talk about this are Resende and Henley. And in both of those, again, we have something that's really noticeable and really unusual. So in Resende, we have someone wearing a really long, big jacket when it's hot, and that's coupled with him doing some strange movement under the jacket, looking like he's trying to conceal something. So there's a connection between, this clothing and trying to conceal. And what we have here is a teenager wearing skinny jeans and a fitted hoodie. I don't think that is particularly suited for concealment. It's not so odd for a teen to be wearing that. Yes, there's testimony that it's a hot day, but it's also 9:30 in the morning. And he's riding a moped, and Walzak concedes
What do you say about this? Because perhaps objectively, the most unusual aspect of the clothing attire that day was the face mask. And it wasn't just a face mask, it was also a face hoodie, what you might wear out to go skiing or to go running or go walking when it's very, very cold out. And of course, this was in August, right? So that, of course, you couldn't conceal a weapon, or not alone a revolver, of course, in that area. So that cuts against it. But what do you say about that as being a factor that was something unusual that the police could consider?
I think perhaps it's something that you could notice and consider, but I think for the exact reason Your Honor raises, the weight.
Yeah, I didn't mean to give you the answer to the question when I asked the question.
Great when you do. But
I'm just opening up the argument for also to have the Commonwealth respond. But
Sure.
If we can agree, all right, hypothetically, if we can agree that that particular item of clothing was somewhat unusual. Of course, I think it was still pandemic time at the end. I think it was
That too,
2022,
yes.
right? So there was that. There was that as well. How could that be part of the calculus, or could it ever be part of the calculus? Is what's probably going to be your answer, is that it never could be. But see if you can help me out here a little bit.
Sure. So I think out of the list of everything we have here, perhaps that's the one thing that officers can say, that's odd, he's wearing this mask. Although, again, I would note the mask is just over his mouth. He is on a moped. But if we're going to factor that in, accepting that, okay. But as Your Honor said, when we're talking about a pat frisk, it's a really strict standard, and we have that strict standard for very good reason. And there needs to be reasonable suspicion that someone is both armed and dangerous. And so I don't see how a mask over your mouth gets you there. Perhaps that allows some sort of inquiry, but that is really not going to be a plus factor, especially in the case like this where we're really missing all the other factors of all the other cases that talk about this. As I stated in my opening, we're not responding to some sort of report of a crime, and maybe if you're responding to a report of a crime and the description is they're wearing a mask, maybe there the relevance really goes up. But here I'm just not sure how it gets you to that armed and dangerous.
So you bring up another point, that at this time there was no investigation of a crime per se. But would you agree that before the pat frisk occurs, that the trooper is aware of the fact that your client is supposed to be in home detention and is not there?
Not before the pat frisk, Your Honor. And so what you see in the video is that Walzak gets out of the car, says, "How are you doing? Got any weapons?" Client doesn't respond, and then 7 seconds after that, he's grabbing his hand to initiate the pat frisk. And his own testimony at the suppression hearing is that, "I attempted to gain control of his hands to conduct a pat frisk. I put him in handcuffs so I could conduct a pat frisk." So by his own testimony, by the time he makes that physical contact, that's the initiation of the pat frisk.
All right, so I differ with your view of the videotape slightly, but of course I'll view it again. My recollection is that there's a conversation or an announcement from the probation officer about identifying the juvenile. And there may or may not have been an initial touching at that point. I will double check. But the actual pat frisk, if we can say that the actual touching of the examination of the waistband, et cetera, that occurs, would you agree with me, after the trooper is made aware of the fact that the identity of the juvenile?
Yes, the actual pat down occurs,
Yes,
but
okay.
the decision to pat frisk, so whether there's reasonable suspicion that he's armed and dangerous, is when the only reason he's grabbing his hands is for the pat frisk. He's not under arrest. And I think something that has occurred to me over the past couple of days as I've been preparing for this is whether I should have separately been addressing that grabbing of the hands as its own separate seizure in advance. And I think if the court is not going to view that as the beginning of the pat frisk, perhaps that is something I could explore in a post-argument letter. But I think the point is that at that point, that's where the stop for the purpose of a pat frisk is occurring. And so we need to draw the line there.
Let's back up.
Yes.
Because when you say a stop for the purpose of a pat frisk, I'm not so sure the record supports that. The stop is legitimate. I think you
initial
agree with
traffic
initial
stop, yes.
Right. So there's a stop, but that's not in order to conduct a pat frisk. The the trooper definitely does conduct the pat frisk, but he needs to have independent justification for that at that time, right? He needs to have a reasonable suspicion that your client is armed and dangerous, which is, I think,
At the time of the pat
your
frisk.
critical argument, which is saying at that time, he
Correct.
did not have that.
Correct, yes. I'm not challenging the initial traffic stop. I'm just, in my mind, wondering if the court is not going to view him grabbing his hands as part of the pat frisk, then perhaps the other way I should have addressed that is that at that point, there's an escalation of the traffic stop into something different under Commonwealth versus Tavares. But even setting that aside.
I can't tell you how to handle it, but I'm going to say there's been a lot of Monday morning quarterbacking, to use another sports analogy today, in this case on both sides. So maybe don't concern yourself. Again, I'm not going to tell you how to handle your case, but maybe don't concern yourself so much with that.
Okay.
The issue really is there sufficient information from which that establishes a reasonable suspicion that he was armed and dangerous.
Right.
But I do think that the timing question is important because from my view of the video, which is not true or even necessarily well remembered, the officer is reaching for your client's hands as he hears first your client's name, and then he's supposed to be on home confinement. Right now, your position, which is, I'm sure, supported by the testimony, is that the trooper admitted, I was reaching for his hands to do a pat frisk. But if one were to disentangle those things, and I think this gets to an argument the Commonwealth made that you say is waived, knowing that this is someone who is supposed to be on home confinement but isn't, was the officer justified in reaching for your client's hands?
So even if we're going to factor in that statement into the analysis, I still don't think that gets you to armed and dangerous. A comment that that's the juvenile, he's on home confinement. That statement has nothing to do with armed or dangerous. It's not a statement indicating he has previous firearms offenses or a statement of, and he runs and he hit the last police officer, something that suggests there's an armed or a dangerous. It's just this kind of uncorroborated statement about home confinement. And so even if we're factoring that in, that has nothing to do with armed and dangerous. And I see I'm running out of time, but I do know that the waived argument that Your Honor briefly raised, if I can just briefly respond to that,
Sure.
Which is that what the Commonwealth seems to be saying is that their primary argument is that, well, there was going to be a search incident to arrest for that technical violation, and there was no arrest for that technical violation. And even after the probation officer...
But if they had probable cause to arrest, then the search might have been justified. I'm not saying that the record is sufficiently developed for that. That's a question we'll have for the Commonwealth. But had that been established, that would be I'm assuming that your position would be slightly different.
Well, I think there are two ways you can get there. Option one is if there is, in fact, an arrest for that violation, then you can say, all right, search incident to arrest, and the search preceded the formal arrest. But here, it's undisputed that there is no arrest for that violation. And even after the probation officer Vanasek says he's on home confinement, after that, the officer still says to him, you're not under arrest. So they clearly do not care about this technical violation. So no arrest, and what is in Commonwealth versus Washington, cited in my brief, is that this concept of a search incident to probable cause to arrest, where there is no formal arrest, that has been flatly rejected by our courts. The other potential angle for this is what I discuss in my brief is perhaps where they're going is inevitable discovery. Do you want me to continue?
I don't think that I need you to discuss that issue because you've briefed it well, and I saw your argument in your reply brief. We have, but I'll just see if there's any other questions. No. So thank you very much for your argument.
Thank you.
Appreciate it.
Good morning, and may it please the court. My name is Melissa Johnson. I'm an assistant district attorney in Plymouth County here on behalf of the Commonwealth. And I first want to address the last part of my sister's argument about the fact that this particular juvenile was not ultimately arrested for home confinement. There is a case that discusses where probable cause to arrest arises and that a person is not ultimately arrested on that charge. However, a search incident to arrest, if there is probable cause, can still occur, and that's Commonwealth versus Vic. The site is 90 Massap Court at 622.
Okay,
And so what
speaking
the-
for myself, the big problem you have here is not necessarily whether or not there was probable cause. Let's put it this way. Had it been developed at a motion to suppress that there was going to be an arrest for a violation of home confinement, whether or not the pat frisk happened before or after the arrest, et cetera, would not have been an issue, most likely. But the problem we have here is that the officer told the juvenile straight out, you are not under arrest. It's maybe an arrestable offense, but there's nothing in the record that says that the officers intended to arrest him for that offense.
Your Honor, I would just point you to Commonwealth versus Petrillo, which talks about the objective circumstances of the encounter. It's not the subjective motivation.
Actually, my bigger issue is that had this been raised below, this would have been explored. There would have been additional evidence solicited, I'm sure, from defense counsel with respect to this. That didn't happen. And our cases, Benton Court, other cases have all said that a theory that could have been pursued and may have even been a successful one at a motion or at a trial is one thing, but when a different theory is then brought to us for the first time on appeal, without that happening, routinely it has been rejected. So what do we do about that?
Your Honor, respectfully, Va Meng Zhou says that this court can affirm.
If the findings support it.
And they do, Your Honor, respectfully. I looked at this record, and the first thing that struck me was that there is enough here for probable cause to arrest at the time that this particular trooper searched for the weapons. And if you look at the case here, as far as you've already seen the video, and of course the video doesn't show absolutely everything. It only shows essentially from the chest up because it's the trooper's body camera. So you take that in combination with the trooper's testimony, we know that, number one, when they first saw the juvenile on the moped, a probation officer recognized the rear passenger as someone that may have been on home confinement. We know that from volume 9, page 14, 22, and 24. So she's recognizing this kid, all right, already before he even stops him. Then he stops him, and as he is approaching him, she says, that's the juvenile's name, excuse me, and he's on home confinement. So at that point, there is probable cause to arrest for a home confinement violation. Whether he was ultimately arrested, according to Vic, doesn't matter. At that point, it's clear, both from the video and from the testimony, that that officer did have.
So hypothetically, if this is raised by the Commonwealth at the motion, and defense counsel asks the trooper whether or not, or asks somebody, is this an arrestable offense? Yes, it is. Is arrest mandated? Do you usually arrest? Was there any condition of the home confinement that could have been in effect at that time that would have changed the outcome of the situation? We don't know any of that.
Well, Your Honor, as I had pointed out with Vic, that those subjective motivations and the knowledge of the officer of whether something is whether they would have arrested that point doesn't matter. You look at the objective circumstances here, and probable cause to arrest certainly arose by the time that he patted this juvenile down. There's no question about that. You look at the record, and there's no question that an arrestable offense arose certainly by the time he was patting this juvenile down. And that's why I wanted to put this argument forward, because it is absolutely clear from the record. And you look at Commonwealth versus Vic, it doesn't matter what the officer, the trooper here ultimately wanted to do, believed to, and even did. It's the objective circumstances here.
All right. So if we were not persuaded that that was that theory was appropriately raised,
Yes.
We have to determine whether or not there was a reasonable suspicion that the juvenile was armed and dangerous.
Yes, Your Honor.
What do you have? and the facts here that established armed and dangerous?
So I would start by just reminding this court that it is, you really look at the collective entirety of these facts, and certainly each one you could pull apart and say there's an innocent explanation, which is what my sister is trying to do. I understand that. However, just starting from the beginning, the trooper here has experience with juveniles. He's been trained in the characteristics of armed gunmen. So we know that from the outset. They are surveilling a particular address, a particular location here. So this is not like a neighborhood or a high crime area. There's a particular location that they are surveilling. And then at that point, and they know that that particular location has been the target of gun violence. So right there we have the setting. Then we see the juvenile as in the back seat of a moped, going by. He doesn't have a helmet. So right there's enough for just a stop. But
The stop has basically been conceded, so I don't think we have to worry about the stop.
Right. So right there, we know that there's a violation that would entail a stop and all of what that entails in terms of that seizure. But what is very, very peculiar about this is that both the rider and the rear passenger are wearing sweatshirts, hoods up, sweatpants, masks on a day which is literally on record the hottest day in the city of Brockton. We're talking in the mid-90s here. And so immediately the trooper is going to be thinking, what are they hiding? What is going on here? Beyond the fact that there is a motor vehicle violation. In addition to the fact that the rear passenger, as they're passing, looks back at the cruiser several times, then the moped actually turns into the exact driveway that they are surveilling. And at that point, the trooper approaches the juvenile, and we see this part is on the video. And yes, he does ask him if he has a weapon. Does that by itself, his non-response, warrant a belief that he is concealing a weapon? No, and the Commonwealth has never argued that. But what Martin is explicit and Elise is explicit is that non-response, in addition to the surrounding circumstances, can be taken into account. Never by itself. A person has an absolute right not to respond to that. But taken with the other circumstances, and you know the setting already, is already very suspicious. The juvenile doesn't respond. He looks away. And then the trooper approaches him. And yes, he does turn his body slightly. It is subtle. You can look at the video in combination with the testimony of the trooper. I believe that the motion judge's findings on this respect are warranted, are supported by both testimony and the video. And we have a trained trooper here that is trained in the detection of armed gunmen. He knows, and he has to make a split-second decision here about what is going on with this kid who is dressed completely inappropriate for the weather. He cannot tell at that point whether he is armed. But based on all of the circumstances, he does have a reasonable belief that he may be concealing a weapon, and that is...
He doesn't really articulate that, does he? You emphasize his training, but he doesn't articulate what in his training led him to these conclusions.
Right, I agree with that, Your Honor, except for when he did talk about the fact that this juvenile was blading, the motion judge didn't let him continue on with that particular explanation. He wanted to explain the whole concept of him turning. But I believe at this point, taking into consideration his experience and the fact that he was subtly turning away from him, not answering his question on whether he was armed, in addition to what he was wearing. And then at that point, we have the probation officer saying, this is the juvenile, identifies him by name, and he is on home confinement. So we know that he is up to no good.
On home confinement, but not knowing the reason, is it a fair inference that leads to danger?
By itself, absolutely not. I agree with that by itself. But we have a whole combination, again, viewing all of these factors collectively, and the fact that the way he is dressed for that extreme weather, in addition that he is at a location which is the scene of prior gun violence, which they were surveilling anyway, So we have all of that in collective, and he has to make a split-second decision here as to whether this particular person is armed. He has a probation officer that he is assigned to protect, who is familiar with this particular juvenile, who visited him just a couple weeks ago because he was supposed to be on home confinement. And at that point, he asked him again, do you have any weapons? And he doesn't respond. Again, by itself, not good enough, but in combination with everything. The pat-down didn't begin. The actual patting of the body, which Torres Began says that's the intrusive part of it, doesn't begin until all of those things happen. And I think that's an important distinction. He's validly stopped. We all agree to that. He's validly stopped, he and the other rider. So at that point, the seizure is fine, and whatever's going on before the pat frisk is fine, because at some point he has to be able to fully identify him, cite him for the motor vehicle violation. We all know that if he hadn't found the gun, that's would have happened. So this stop was going to happen. It was going to be a prolonged stop because he would have had to identify and cite him.
So if the pat frisk starts with the touching, I guess which touching? Because before the officer starts feeling around for weapons, he handcuffs the juvenile.
Yes.
Is that the beginning of the pat frisk?
I believe it would be the actual touching of the body, the intrusion of the body.
So what justified the handcuffing then?
I believe just to keep him still, because he wasn't keeping still, he was turning away from him. And the fact that there was another person there, there's a variety of circumstances that can go into why.
There were two armed officers there.
There were two armed officers there, but there was a probation officer that he was trying to protect. So
There was nothing happened at the stop that indicated, or can you tell me whether or not there's something happened at the stop that would have put the probation officer in any kind of danger?
other than the fact that the juvenile was armed?
Well, they have to know that
They
and
have
have
to know
suspicion of
that.
that beforehand. You can't look at the end and go back and
I
go
agree.
backwards.
I agree with that, but I believe that there was suspicion at that point, given the location. The location had been the scene of violence before, of gun violence before. So there was a reason why these troopers were accompanying the probation officers on their various warrant checks.
Is there any evidence in the record about whether this particular juvenile was one of the people on the list for the warrant checks that day?
There's nothing in the record about that, Your Honor. There's nothing in the record. So again, I would...
While your time is almost up, I do want to ask you about the sufficiency of the evidence.
Absolutely, Your Honor.
Because very short trial.
Yes.
Would you agree that the only evidence of knowledge of the firearm being loaded came from the video?
From the defendant's statement, which was recorded on the video.
Right. In other words, no testimony about it, no one gave a transcript to the judge, no one said anything, they just showed the video, and that was the only evidence of respect to whether or not the juvenile knew about the firearm, had knowledge of the firearm.
Well, I believe that the trooper actually also testified as to the capabilities of the firearm and what the juvenile had said, why he had moved so quickly. So I think he just repeated what the juvenile had said. And I would just point this court's attention to Resende and to Grayson to distinguish, certainly, because we have someone who put a firearm in their waistband, which there can be an inference that he knew it was loaded. And the fact that he just stated, the reason why I moved away from you, trooper, was because I thought that thing was going to fire. And here we had a 1 round in the chamber, 3 in the magazine. The trooper testified that particular weapon doesn't have a safety mechanism. It's a semi-automatic, whereas it would have gone
Of course,
out. Yeah.
the issue here is what the juvenile knew about that. And if the juvenile knew that, not what the trooper knows about it after it's been examined.
And I would just say
So there's
that
no evidence that the juvenile knew any of that.
Absolutely not, except for that his statement seems to insinuate that he knew that thing was ready to fire. That's why he backed away.
Okay. All right. Any more questions?
I'd rest on my brief if there are no further
All right.
questions.
Thank you both very much.
so
Then we had a lot of questions, and if they seem pointed at some points, I know that you will forgive us, but we need to get to the bottom of all the issues in the case. Thank you very much. The next case is Kamo versus Makala. I'm going to, excuse me for mispronouncing the first name here incorrectly, but Kamo versus Makala K. Lowe, 2023-1439. Good morning.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. Today, the Commonwealth is asking that Your Honors conclude that the plea judge, Justice Salinger, erred as a matter of law in concluding that the Commonwealth's indictment was insufficient to provide notice to the defendant that she was charged with the sentencing enhancement of armed robbery committed with a firearm, and that he further erred in denying the Commonwealth's motion to revise and revoke an illegal sentence after he imposed it. I'd like to start by addressing a point that the Commonwealth didn't necessarily address in its principal brief, but that was raised by the defendant in his brief, or in her brief, excuse me. This idea that it's an either-or proposition, that the Commonwealth is required to bring separate counts in an indictment to alert a defendant that they are being both charged with armed robbery with a dangerous weapon and armed robbery with a firearm, because those are separate offenses. And the Commonwealth would strenuously dispute that. It is a sentencing enhancement, both to be masked and to commit the crime with a firearm, shotgun, or one of the other enumerated weapons. So while the Commonwealth agrees 100% with the defendant's position that had this case proceeded to a jury trial, we would have had to put this to the or a bench trial, would have had to put this to the fact finder, and it would have had to be proved beyond a reasonable doubt before the minimum sentence could be imposed, if incarceration was in fact imposed. That does not mean that it is a separate offense and that the Commonwealth is hamstrung in the sense that it has to either pursue an armed robbery with a dangerous weapon or pursue an armed robbery with a firearm. And I would submit to the court that the Garrett case does not support what my brother suggests it supports. While the court in Garrett does repeatedly note that the defendant, quote, was not charged with armed robbery while armed with a dangerous weapon, which is technically correct because, as Justice Gantz notes in his concurrence, this was a peculiarly drafted indictment in that case where the Commonwealth chose not to include the dangerous weapon language. I would submit that the Garrett court does not say that these are separate crimes, and rather, if you look at Chief Justice Gantz's concurrence, he accurately notes that both being masked and having a firearm are in fact sentencing enhancements. And he notes, and I'm just going to quote the relevant language, quote, "For the reasons given by the court, the Commonwealth was not entitled to the sentence enhancement arising from the commission of the armed robbery with a firearm because a BB gun is not a firearm." And so there, the Garrett court is not saying these are separate crimes, you have to separately charge them, and the Commonwealth can't have its cake and eat it too, as my brother tries to frame the argument. But rather, this is a sentencing enhancement and the defendant just requires notice of it. And I just anecdotally want to note that there's a reason for this, right? Like committing an armed robbery with a firearm is very serious, but no less serious is committing an armed robbery with, say, an inoperable firearm, right? That is still a dangerous weapon that still carries a potential sentence of life in prison.
Right, but not the mandatory minimum.
Not a mandatory.
Right.
The point I'm trying to make being, here we had a case where the gun was fired. We knew the gun was operable. It caused injuries to the victim.
Yeah.
But suppose a case where a firearm is brandished but not fired, and it turns out that that firearm has, say, a dented firing pin or some other minor issue that requires a ballistician to take certain efforts to render it operable. That would then have to be submitted to the court at any subsequent bench or jury trial, and if for whatever reason the finder of fact were to conclude that that was too much tinkering to render this an operable firearm, then the Commonwealth would now, if my brother's argument is to be believed, be stuck with an unarmed robbery conviction rather than the appropriate conviction of armed robbery with a dangerous weapon. And again, I'm sorry, did Your Honor have a question?
Well, seems to me that the main issue here is just simply whether or not the defendant had notice.
Correct.
And second, whether or not, why the Commonwealth couldn't simply just amend the indictment. I mean, if there was a variance in the indictment, I mean, it says to wit a firearm instead of with a firearm. What precluded that solution? in this case?
Well, I think there is a not incredible argument that amending it at that moment would have been amendment as to substance and not form, if the argument is that it alleged only armed robbery with a dangerous weapon, and it would be amended to armed robbery with the sentencing enhancement of a firearm, which would carry a more severe sentence.
And at that moment...
But I don't think we have to...
Hold on.
I just want to make sure I understand. When you say at that moment, do you mean during the colloquy that
Yes, Your Honor.
preceded the plea?
Yes, Your Honor. But the Commonwealth's position is that's not necessary. And I did submit a 16L letter to this court. I'm not suggesting in any way, shape, or form it's dispositive of the issue. But the language here largely, it said to wit rather, and that weapon was. But if you look at the suggested language in the district court complaint manual, it literally says armed robbery with a dangerous weapon, which was a firearm.
That was a firearm.
That was a firearm. And although
Which is not what the indictment in this case says.
That is not specifically what it says, but the to-wit language is the functional equivalent of that. I think, just to
Isn't
play
that
out,
what the judge was upset about? He wanted the indictment to say with a firearm?
he wanted the indictment to not include the dangerous weapon language. He viewed it as necessary for the Commonwealth to allege that this was an armed robbery with a firearm, not armed robbery with a dangerous weapon, to-wit firearm. And his view was that that was charging two separate offenses and wasn't giving the defendant sufficient notice. And again, that's simply not accurate. To just return to Garrett, the issue was that the Commonwealth chose not to include that dangerous weapon language in Garrett. It was an issue of notice to the defendant, like whether the crime charged was proved as charged at trial. So if, for example, in Garrett, the Commonwealth had indicted the defendant with armed robbery with a mace, and then didn't prove at trial that the dangerous weapon was a mace, the same issue that arose would have still been present, because the Commonwealth didn't tell the defendant, you're being charged with armed robbery with a dangerous weapon, and oh, by the way, we're alleging that it's this particular weapon, which in the case of a firearm carries a sentencing enhancement. They just said, you're being alleged to have committed armed robbery with this particular weapon. And because they weren't able to prove in that case that the BB gun was that particular weapon, a firearm, they were in trouble. And again, Chief Justice Gantz notes that in his concurrence, noting the peculiar manner in which the Commonwealth chose to indict and suggesting that in the future they do include this dangerous weapon language and allege a sentencing enhancement. And again, it's the Commonwealth's position that here that was sufficient, which notably is supported by both the sentencing recommendation and the explicit statements of defense counsel here. Defense counsel notes on the record that, quote, the minimum sentence for armed robbery with a gun is 5 years, and that's why I'm asking for 5 years to 5 years and a day, quote. That's at page 12 of the colloquy. That's before the judge sua sponte, without any suggestion from defense counsel that there's an issue, raises this Article 12 notice issue. So the defense, and again, right before the court recesses at page 15, again, counsel acknowledges, quote, been operating under the assumption that there's a minimum, end quote, because a firearm was used. So this defense counsel, who has presumably advised his client prior to the plea colloquy what is being charged and what the likely sentence is acknowledging on the record that the Commonwealth's indictment language is sufficient to provide his client notice.
But I mean, if it actually was not sufficient, counsel's statement that, counsel's acknowledgement wouldn't change the playbook, right?
I suppose that's true if Your Honors conclude that as a matter of law, this indictment language is insufficient, but I would suggest that there's nothing in the case law that supports this allegation that it isn't sufficient.
How about Prado? Can you address Prado? Because your
Absolutely.
brother makes much of it.
The Commonwealth's position, as articulated in its original brief, is that the Prado case is peculiar to its facts. And I think I will specifically address Prado, but I would say that that's the case for all of the citations that my brother offers for this spurious allegation that to-wit language has been deemed superfluous. Hobbs, Harris, Prado, they all, if you read them, are concluding that in the context of those particular cases, based on what's happening in those particular cases, the to-wit language is superfluous. So in Prado, the reason that they conclude that the to-wit firearm language is a non-fatal variance is because of how the case proceeded at trial. It was not tried as an armed robbery with a firearm. It was tried as an armed robbery with a BB gun. The jury was instructed on the standard armed robbery jury instruction with a dangerous weapon, not armed robbery with a firearm. The defendant did not, as the court noted in a footnote, object to those jury instructions or object to the way the case was presented to the jury and the result at trial. It is because of those facts, because the case as presented to the jury matched the evidence and the defendant did not object to the way the case went, that the court said, quote, in the context of this case, the to-wit language was superfluous, end quote. So the court is not saying, as a matter of law, to-wit language is superfluous and it cannot support a sentencing enhancement. They're just saying that based on how the case was tried, that's what happened. And again, just to return to the Hobbs case, which my brother holds up as this beacon of to-wit language being superfluous as a matter of law. There, we are dealing with an armed burglary with the intent to commit a felony, right, which is one of the elements you have to prove. There is no felony in the context of an armed burglary that results in a more severe sentence than another felony. So it's sort of beside the point in the context of Hobbs, because whether you're doing an armed home invasion, whether it's an attempted murder, whatever it is, you're getting the same sentence. Here in this statute, the court is specifically noting in 265-17, whoever commits any offense described herein while armed with a firearm shall be punished. It's clearly a sentencing enhancement, and the Commonwealth needs to let a defendant know in the indictment that the firearm is the particular weapon that they're alleging to get. In the same way that we say the defendant, while masked, committed an armed robbery, and you get the sentencing enhancement for that, which is frankly identical to the firearm one unless we're talking about subsequent offenses. So to reiterate, no case law says the to-wit language is superfluous as a matter of law. Those cases are all specific idiosyncratic cases decided on their facts based on how the cases were tried to the jury, which didn't happen here. And again, and the district court complaint manual largely tracks the indictment language the Commonwealth used here.
But it's later, right? I mean, the version of the manual you sent us is
It was updated in 2023, but the entry I submitted suggests that it was added in the 90s and hasn't been amended. So the manual as a whole, which contains literally every possible code, was most recently amended in 2023, and I felt that was important to note. But if you look at the entry that the Commonwealth excerpts, it was added in, I believe, like 98.
Yeah, you're right, October.
So it hasn't been changed since then. Okay. And this is not really, I just feel like it's worth mentioning, and the Commonwealth mentioned in its motion to revise and revoke. The motion judge, in bringing this up sua sponte, suggested that the Commonwealth was providing inconsistent positions in different cases. But the Commonwealth, in its motion to revise and revoke, provided various case citations and documents anecdotally to show that the same crime had been indicted the same way in numerous instances, and the judges had imposed the mandatory sentence, assuming they decided to, incarcerate the defendant. And at no point did the motion judge ever elaborate or provide the Commonwealth with the names of ADAs that allegedly had
That might have been asking a little bit too much.
None of that is before us.
Or any docket, but the point being, the Commonwealth provided numerous instances where the same court, the Lowell Superior Court, had provided the mandatory sentence on identical indictment language. And so this was not a situation where the Commonwealth is choosing to indict different cases in different ways and trying to take inconsistent positions.
No, but the Commonwealth has to get it right. That's the whole point. That's the point that the judge is bringing up. What is the right way of doing this?
Right.
To make sure that we're comporting with the Constitution. And of course, in this case, as you point out, defense counsel was aware, of course, had the grand jury minutes, et cetera. You cite the Wentworth case showing that there was notice there, but point well taken. I think that the language of the indictment needs to be precise.
Agreed.
I'm not saying if it was right or wrong right now. I'm just saying that the issue raised is not one that.
And again, and I'm sorry, I can't remember if it was Justice Hirschfang or Justice Singh that raised this point, but I would just cite the court to both Canty and Wentworth, which they're not directly on point, but they do also speak to the idea that the sentencing recommendation at a plea colloquy and the facts submitted to in the plea are relevant to an assessment of what was charged and what was understood. And here, if you look at page 33 of the sentencing transcript, the defendant admits to an armed robbery with a firearm that was fired that caused injury, after her counsel previously admitted that he understood it to charge the sentencing enhancement and was therefore requesting the 5 to 5 and a day sentence. So both the record and the law, I would submit to your honors, fully support that the indictment language used here is sufficient to provide that Article 12 notice to the defense. And again, I will note that had it proceeded to trial, the Commonwealth would have absolutely expected to prove beyond a reasonable doubt that there was an operable firearm and to have had the jury note that either on a special verdict form or some other specific notation so that the record would be clear. But in the context of this plea colloquy, this indictment was sufficient, the defendant had sufficient notice, and therefore Justice Salinger erred in concluding that the Commonwealth failed to properly charge the firearm sentencing enhancement, and he erred in denying the Commonwealth's motion to revise and revoke his illegal sentence. Thank you. I'll rest on my brief.
Any further questions? Thank you very much.
Good morning, Christopher DeMeo from Michaela Lowe. So a lot has been said about notice, and that's an important issue, but I think there are other issues here too. To frame this case as the Commonwealth does about whether the defendant here was on notice that a sentencing enhancement was applicable kind of begs the question of was it applicable, and our argument here really is it wasn't. And I think when you read Judge Salinger's opinion, he starts off talking about notice, but then he goes on. This is page 2 of his opinion, page 22 of the Commonwealth's brief in the addendum. So he starts out talking about the armed robbery indictment in this case did not fully and plainly, formally or with any precision put Ms. Lowe on notice. But then he goes on to say, to do so, the Commonwealth would have had to convince a grand jury to indict her for committing armed robbery with a firearm or with a handgun. Indicting Ms. Lowe generically, using the to-wit language, did not expressly invoke the enhanced penalty.
So I guess the piece of that I'm having a fair amount of difficulty following is Judge Salinger seems to create, at least in the section you just read, some space between with a firearm and to-wit a firearm. Isn't to-wit just a super old school way of saying specifically this?
No, my understanding of the word to-wit, and I actually looked it up on Google, it means namely, or for example, or it means namely, actually. So,
And doesn't namely mean specifically?
the way, I mean, if we were writing on a blank slate here, you might think, well, that's what they've got to prove. But there are lots of cases, and I don't really understand. I know my brother's purported to distinguish all of them, but if you go back and you read them all, Prado, the whole line of cases going back to 100 years, they say that this does not hem in the Commonwealth, this does not hem in the prosecutor. They simply have to prove it's a dangerous weapon. And what's the issue here, and I think what got Judge Salinger's goat maybe, was that they used the exact same language from Prado, and it's clear from Prado they didn't have to prove it was a firearm. So that was.
Doesn't Prado stand for the proposition that if you indict with this language and you fail to prove a firearm, you haven't failed to prove an armed robbery? You've only failed to prove an armed robbery with a firearm? That's correct.
Yeah, Prado is the case that had a BB gun, right? So in that case, right. But the point is the firearm was illustrative. It didn't matter that it said with a firearm. And it's the same thing here. If they had gone to trial, and on the facts of this case, somebody got shot, so there seemed to be a functioning gun. But if they had gone to trial and for whatever reason, the Commonwealth opted not to pursue the firearm charge, they could have just, the question for the jury would have been the model instruction, which we put in the addendum, which is, was a dangerous weapon used? So I don't actually understand my brother's, he's saying at some point it was going to be put to the jury. I think we all agree if there's a sentencing enhancement under the Sixth Amendment, the jury has to be the one to find that fact here, the sentencing enhancement fact being that a firearm was used. But I don't, as this is written, it appears to, you would just be using the standard dangerous weapon instruction, because I know it's sort of nitpicky, but I mean, the devil is in the details with these things, and they've read the Prado case, this to-wit language has been given specific meaning over the years, and it does not bind the Commonwealth to prove that particular weapon when it says to-wit a gun.
So you're saying it does not bind the Commonwealth, so that, to follow your argument, you're then saying, since the Commonwealth is not bound by the to wit language, there's no notice to the defendant as to what the Commonwealth is going to be bound to?
Yeah, yes, that's true. And I guess the other half of it is, and this
But
is
here, of
the other
course,
point.
the to wit does say exactly what the weapon involved is, right?
Yes, the to wit says what the weapon involved is, but the problem is, and this is the other point that seems to have perturbed Judge Salinger, is the trial jury can only try the charge that the person was indicted for. So this language we know, or I'm submitting that we know from Prado and that whole line of cases, is simply makes out a claim for dangerous weapon, not for firearm. Therefore, that is the claim. If I'm right about that, then that's the claim that has to be submitted to the jury. So it never comes into it that, and by the way, we're going to ask the jury, did he have a firearm? Because that's not the charge. The jury would get the jury instruction that I put in the addendum, which is just for dangerous weapon. So I don't see how that could be put to the jury. Now, I appreciate the argument that it would be nice for the Commonwealth, I understand, if this was all, if a firearm was the greater charge and the lesser included was with a dangerous weapon. And as I say in the brief, you might have thought as an original matter that's the way it would be. But I don't see how you can read the Garrett case and think that, because they say they're two distinct crimes, they're two distinct indictments. And in that case, the lesser included offense was unarmed robbery. I mean, even if he wasn't indicted, I mean, all the time courts impose a lesser included offense for which a person was not indicted. So it doesn't matter. It may be true, as my brother says, that in the Garrett case, he hadn't been, the indictment apparently didn't make out dangerous weapon, but if that was the lesser included offense, that's what the court would have done. But they didn't do that. They went all the way down to unarmed robbery because they don't stand in a greater lesser
that was
relation.
because of Garrett and the BB gun issue, right? I mean, I guess I'd like to get back to the first thing you said, I mean, most recently, first thing, about to wit firearm. Am I right to understand your argument that the words to wit firearm are basically meaningless in your view?
Yes. I mean, that's, this court, again, that has described them as superfluous. So, I mean, they're meaningful in that they do give notice in the sense that you might not need to ask for a bill of particulars, or you might, for due process reasons, if you wanted to know what was going to come out at trial and who the witnesses were going to be. But in terms of, setting forth the elements of the crime, that's not an element of the crime. It is superfluous.
Well, it's a sentencing enhancement, right? I mean, I guess if I were you, I don't think I would concede the due process issue so quickly, because Article 12 says you can't be sentenced for something unless you knew what was coming, right? It doesn't actually say that, it's more articulate.
Right.
But here, the word firearm with this specifier to wit appears in the indictment. So isn't that enough to put Ms. Lowe on notice that the Commonwealth intends to prove that there was a firearm and therefore that there's a 5-year mandatory minimum sentence?
I would say no to that, because again, that language sets out a crime which is with a dangerous weapon, and it does not put any burden on the Commonwealth. I get that they could if they wanted to try and prove a firearm, but at the time the grand jury indicted, they said it was a dangerous weapon, and it follows from that when you go to trial, that's still going to be the charge with a dangerous weapon, and the elements are going to be dangerous weapon. It's not going to be about, was it a functioning firearm that projected
But the grand
shot.
jury indicted dangerous weapon to wit firearm.
Right.
So presumably, evidence was presented to the grand jury that was sufficient for the grand jury to conclude there was probable cause to believe that a firearm was involved.
I believe, certainly. I mean, if the DA who was dealing with the grand jury had given them one that said, did commit armed robbery with a firearm shotgun or something. I'm sure they could have done that, but they chose this dangerous weapon one, which limits the issues that are going to be put before the jury when it goes to the jury. So I don't see it at the end of the day how the jury could ever make a factual finding to increase the sentence, on which they've got to do.
So your contention, well, it doesn't increase the sentence. It increases the mandatory minimum
Sure.
sentence.
But for the Sixth Amendment, it's the same issue.
So I lost my train of thought. It had something to do with the indictment. I think I was going to ask do you contend that the Commonwealth needs to elect at the point where it's seeking an indictment from the grand jury whether to indict dangerous weapon or firearm?
Yes, I mean, that's my point. If you take that these are separate crimes, as I read Garrett, it says they are, and as I think you have to infer from what actually happened in Garrett, where they went down to unarmed robbery. If these are not inclusive greater, lesser offenses, but they're separate, they've got to make a choice, because, I mean, it can't be that there's one kind of inchoate armed robbery indictment, and then the Commonwealth at some later point decides, well, it's going to be just dangerous weapon, or it's going to be with a firearm. They've got to go with what.
So you would say it would be a material variance, that it couldn't just simply be a not material variance in the indictment and just be amended, as often happens.
I agree with
to conform with
yes,
the
yes,
to conform with the
it would be
evidence
material.
in the case.
Because it's a whole new element. With the firearm, you have to prove it's a functioning firearm, whereas dangerous weapons. So
Presuming, of course, that was all put in a trial, which it would have been, you still say that it would not be, that would be a material
it would be a material
variance?
variance, yes. It's a whole, I mean, it's a different crime. I mean, they're both within Section 17 of the statute, but as I read Garrett, they're separate crimes. So yes, you have to make a choice, and I understand why you wouldn't want to do that if you're the Commonwealth. You want to have the most flexibility, but so if you go with the firearm, you get the greater mandatory minimum, but then if something goes wrong and you don't prove the firearm, then you end up like in the Garrett case, and it goes down to unarmed robbery.
Or you could have
Whereas
two
if you
indictments. Or you could have two separate indictments under your theory.
You
One for
could.
dangerous weapon, the other for firearm.
I suppose so. It's kind of weird, because
Yeah, that is weird.
it seems like it'd be double jeopardy, but that's,
Well, it would avoid the scenario that you just brought up.
yes, yeah. So that's how I read the cases. So to me, it's, this case certainly raises issues of notice, but it's really broader than that. It really goes to, well, what is the statute? Does it set forth two separate crimes? And if it does set forth two separate crimes, then what's happening when the jury indicts? And isn't it kind of weird here that the Commonwealth used the very language that was in Prado in this case that relieved them of having to prove a firearm? So
Well, I mean, presumably that's language that's been used for centuries, but maybe that'll change.
right.
I take it you don't have any objection to the language the suggested language from in the district court, district court complaint, which just says with a firearm.
I don't really like this language because it says a dangerous weapon, which just, as I said in the brief, I mean, if you can have robbery or assault and battery or whatever with a dangerous weapon or with a firearm, and if they're two separate things, I see no reason to combine them like this. This is a little better because it says that is rather than to wit, and that is a little bit more restrictive, maybe, that it is that particular weapon. But yeah, but I don't even know where this came from or if it's written by district attorney. This was a new one to me, so. I will say, Ms.
You don't have a copy of the manual right there on your...
I mean, I will say, as I look at the statute, the statute says whoever being armed with a dangerous weapon does all the bad stuff shall be punished by imprisonment in the state prison for life or for any term of years. And then in the next sentence, whoever commits any offense described herein while armed with a firearm, etc., shall be punished by, imprisonment for not less than 5 years. That doesn't I mean, whoever commits any offense described herein, would you agree with me that that's a reference to whoever being armed with a dangerous weapon?
I don't know what that means, actually. I mean, if it meant that, then I wouldn't quite understand how I wouldn't understand the holding in Garrett, which I think we have to take that as the definitive interpretation of that statute. Since I'm about to be out of time, I'll just mention Ms. Lowe is coming up for parole in late March or early April, so yeah, she was concerned.
We saw your joint motion to expedite.
Right. Unless there are questions, I'll rest on the brief. No. Thanks.
Thank you.
Thank you.
All right, we're going to hear one more case before we take our morning break. Next case is also partially impounded, AB versus JB, 2024-0041. Good morning.
Good morning. Good morning, Your Honors, and may it please the Court. My name is Brian Waller, and I represent the plaintiff and appellant, AB. AB suffered domestic violence throughout her marriage to the defendant. When she was granted an initial restraining order pursuant to Chapter 209A from a hospital bed following a vicious attack in which she was suffocated with a pillow until she fell unconscious, came to again, and was choked with the believed to be the belt from a robe. When she woke up from that, she played dead and was able to survive. She heard her husband at the time calling 911 and saying that he thought she was dead.
We are familiar with the facts. If you don't mind, I'm going to ask you a question.
Sure.
Which is, are you asking us to say that the judge abused her discretion by failing utterly to consider giving you what you had requested, which is a permanent abuse order, or are you asking us to actually say she abused her discretion and order her to enter it?
The latter.
Okay, which is why you're concentrating on the facts right now. Okay.
Yes.
And you would also tell us, I presume, that we don't need to have a judge review any more facts or review that issue independently before we do?
Correct. I believe the judge was presented with everything that Your Honors have seen. There's no dispute or no question as to the plaintiff's credibility. There were no questions asked by the judge as to.
But that's because, of course, the judge was not going to consider whether or not a permanent order should enter.
I'm sorry, sir.
The judge did not consider whether or not a permanent abuse prevention order should enter. She would only consider an extension.
That's correct. So she abused her discretion by failing to exercise that.
Why wouldn't it be equally appropriate, or maybe more appropriate, for us to hypothetically to remand for a different judge?
That would be an option. However, what I was hoping to avoid was forcing my client to attend
Go back
another
to
hearing.
court.
But that was an option that was available right then. The judge stated, just so you know, I'm not going to give you a permanent. You can go to another judge. I won't take any offense. But you didn't take that option.
No, because that would have meant coming back on a different day, her reliving this yet again. And it was kind of shocking, honestly, to hear the judge suggest that we needed to essentially forum shop to obtain relief that is available. And the reason, just by way of a little background, my client was hesitant to even attend the hearing in 2023 because of what had happened in 2021 when the
I was just
order
going to ask,
extended.
you had already asked for a permanent order once before from this same judge.
Correct. And she did not want to attend because she expected the same thing, that it would only be extended. And I encouraged her to attend and said that we would appeal it if it happened again. And for the 2023 order, I added additional case law and additional facts to the affidavit and made it very clear that the judge was vested with the authority to grant a permanent order, and that there's a case exactly on point that addresses a judge refusing to exercise their discretion.
But it is still a discretionary call. So granted, in this case, the judge said, I'm not going to do that. I don't do that. But it's still a discretionary call. So under that scenario, how can, you're asking this court to say that that was a mandatory result based on the information that was given. But that can never be the case if it's a discretionary determination, can it?
So the judge raised no questions as to the credibility of the plaintiff, the underlying facts, which were uncontested. The defendant made no argument against any order at any time, and definitely no argument against a permanent order. So her reason for denying that order was her own personal philosophy and protecting the defendant's due process rights when he hadn't asserted any of those rights himself.
So to follow up on Justice Singh's question, I just want to understand the contours of your argument. And I know this didn't happen, but if, for example, the judge had said, I take your submissions, I credit your affidavit, I hear what you're saying, I have the discretion to give you a permanent order, but in the circumstances here, I believe that what is appropriate is not a permanent order, but actually a 2-year extension. Would you still have an appellate issue in that case?
I don't believe so. And had the judge raised credibility concerns or given any reason for not granting the order that was exercising that discretion, however, she stated none of those in concluding that she would not issue a permanent order.
Okay.
So in Lonergan Gillen, which is the appeals court case from 2003, the facts are extremely similar. I think the difference there was that permanent restraining orders, there was some sort of confusion around 1999, 2000, prior to the SJC's decision in Crenshaw as to the authority of the courts to enter permanent restraining orders. Lonergan Gillen, however, made that abundantly clear that it was an abuse of discretion for a judge to fail to exercise their discretion. It's been 20 years since then. And it's unfortunate that a plaintiff has to go to such lengths to obtain something that is, the judge is vested with the authority to grant. And my client wasn't the only one the day that I was there that was denied a permanent order for the same reason. And I'm not expecting this court to do anything further than the specific plaintiff that I'm asking for relief for. But there is a broader problem here, that there's a community that is not able to obtain permanent restraining orders because of a judge's personal philosophy. And that is troubling and concerning that it requires such great lengths to address this problem. But each of those plaintiffs would have to go through the same process or take the judge's advice and seek out a different forum. And that's simply not the way the system is supposed to work. So here, it's clear that the judge ignored the law, ignored the facts of this particular case, ignored any
I
concerns.
think it's fair to say
from
that the judge even recognized herself that she was not going to apply the law, which is why, as Justice Singh points out, she said you can go to another judge. I think there's another judge that appears on Wednesdays in that court. Is that what she indicated in her?
Yes, I believe
Yeah.
that was what she said. And it's frustrating that a plaintiff in this situation that suffered such horrific abuse at the hands of the defendant essentially has less consideration from the court than the defendant that didn't appear and didn't contest the issuance of the order. If the court has no further questions, I will rest on my brief.
No further questions, no. Thank you for your argument.
Thank you.
All right, the court will take its morning recess now.
Court, all rise. Court is open, please be seated.
Okay. The next case on our list is Patricia Fennelly versus New Resic and another, 2024-0076. Good morning.
Good morning, Your Honors, and may it please the Court. Attorney Todd Dion on behalf of the appellant Patricia Fennelly. The issue in this appeal concerns whether or not New Res complied with Federal Regulation 24 CFR 203604B and D as incorporated in paragraph 22D of Patricia Fennelly's mortgage contract, which required that the mortgagee make a reasonable effort to arrange a face-to-face meeting with the mortgagor prior to and as a condition precedent to acceleration and foreclosure. 24 CFR 203604D specifically requires that, quote, a reasonable effort shall consist at a minimum of one letter sent to the mortgagor certified by the Postal Service as having been dispatched, and furthermore that such a reasonable effort shall also include at least one trip to the property if there is a branch within 200 miles of the property and if the mortgagor resides in the property. The lower court committed a clear error by interpreting the language of Section D as articulating the certified letter and the trip to the property requirements as alternative requirements connected with the conjunctive or, rather than two necessary and required elements of the regulation.
And I think your brother concedes that, right?
I don't believe, I don't believe that.
Well,
I
he'll
guess
tell
he
me if
does.
I'm wrong, presumably.
I haven't seen any argument against that in his briefing. No, so as far as this regulation goes, the court committed an error in stating that because the trip to the property element was complied with, then the regulation was complied with. But it's very clear from all of the cases that I've cited throughout the country and from the plain language of the regulation that both a certified letter and a trip to the property are required.
So what about, you say both a certified letter. Is it a certified letter that's required, or is it some other kind of letter?
At page 7, the court stated that the parties had agreed that it is a certified letter must be sent.
Okay.
That's not what it says, though, right? By it now, I mean the reg.
Well, it says a letter certified by the Postal Service as having been sent.
Okay.
Dispatched.
As having been dispatched. So it would be easier if it just said via certified mail. I understand that. But according to that plain language, if it's referring to certified by the Postal Service has a specific mechanism to certify, and it's certified mail with a tracking number, and the purpose of which is to track it and make sure that it went to the appropriate address.
So you've said a couple things there that I want to follow up on. First of all, there's nothing in the reg that says certified by the Postal Service as having been dispatched to a certain address, right? It says certified by the Postal Service as having been dispatched. I don't mean to suggest that if it's sent to flagrantly the wrong address that that's okay, but I don't see those words that you just said in the reg.
Well, it's consistent with the trip to the property requirement, and also that I believe Section B says it's a reasonable effort with the mortgagor, and the only address that New Res has for the mortgagor is the property address. So yes, it should be the property address.
So your client is not arguing that your client, that was not going to be a good question. Your client concedes that certified mail, by which I mean the little green sticky on the outside of the envelope, is the only permissible way of notifying the mortgagor under the reg, subsection D?
Correct. Yes. It's the only interpretation of that language that makes sense.
Well, I disagree with that. I mean, for example, if one is to were to send a letter by priority mail, you get a receipt, and the receipt shows that you paid for it, it shows the address that it went to, and it comes from the Postal Service. But you're not arguing that would be certified by the Postal Service as having been dispatched.
I'm arguing that, yes, it needs to be quote-unquote certified mail, but if we're going to read the language to mean just without it being certified mail, just a certification from the post office that it was sent, I don't see that here. We have the evidence that the appellees have provided is from a third-party mailing, appears to be a third-party mailing service. I believe they're called NCP Solutions. It's not from the actual company. It appears to be a mailing service, third-party mailing service that was hired to send mail. It's not from the United States Postal Service. The only evidence from the United States Postal Service is this evidence of bulk mailing, which specifically says this certificate does not provide evidence that a piece was mailed to a particular address. And I believe that negates the whole point of the mail being certified to show proof that it was in fact sent to the mortgagor. So I believe the court agreed with that. There was no reasonable inference from the evidence that it was sent certified mail. There's no tracking number, there's no actual stamp or anything from the United States Postal Service.
But that goes back to the earlier question that the language of the regulation requires that it be certified as having been dispatched, but there's no additional language requiring certification to a particular address, right?
I would say that is implicit, that it should be the address of the mortgagor. That I mean, it can't, like the court had previously said, that it shouldn't be sent to a... Well,
no, but the regulation indicates that the letter should be sent to the mortgagor, but that the certification only needs to certify that that letter was dispatched.
Yes, and I don't see how this bulk mailing shows that it was dispatched particularly to the mortgagor.
Well, I think the point you made earlier, which is a more precise point, is whether or not the certificate of bulk mailing shows that it was sent to the mortgagor, it is not certified by the Postal Service as having been sent to the mortgagor, right?
Correct, yes. Yes, there's no actual certification from the post office as the regulation requires sending the letter to my client. And I would argue that, yeah, there is a particularity element to that as well. It obviously needs to be sent to the mortgagor at their address. And especially since the regulation, if you look at the other element of it being a trip to the property, that encourages the idea that, yes, it needs to be sent. The letter should be sent to the property as well, because we're talking about notification at the property. So at this point, I think it's a very brief argument, and I really don't have much else. If there isn't any other questions, I'd rest on my brief.
Do you want to address the prejudice argument that is made by New Res? In other words, in the they maintain that in the circumstances here where there have been multiple years of non-payment, even if it was error not to have proven both methods of notice or opportunity to have a face-to-face meeting, that there's no conceivable showing that it would have made a difference?
Well, it's a strict compliance issue. It's a condition precedent. The regulation is a condition precedent to acceleration and foreclosure. So therefore, under Pinty, which I believe this court has cited Pinty in the Jose decision, and I believe it may have been cited in Cook, that strict compliance does not require prejudice to the mortgagor. So it doesn't matter. Because of the benefit that the bank has in being able to take property without judicial oversight, when you have a condition precedent, they need to strictly comply with the terms of the mortgage in accordance with Section 21 of the statutory power of sale. They must first comply with the terms of the mortgage. It's a term of the mortgage that they strictly comply with this regulation, so therefore prejudice is not required.
Okay.
Anything else? Okay. Thank you, Your Honors.
Thank you very much. Counselor?
Good morning, members of the panel. May it please the court. My name is Mike Lane. I'll be arguing on behalf of New Res LLC, which was the lender and defendant in the Superior Court action. I guess I'll start with Your Honor's questions about going straight to the statute. So the statute reads, reasonable effort shall consist at a minimum one letter sent to the mortgagor certified by the Postal Service as having been dispatched. Now, when we think about what does that mean, we know from the case law that rigid interpretation has been widely rejected. For instance, we know that the phrase by the Postal Service as having been dispatched does not mean that proof must come from the Postal Service.
So what case do you cite in support of that proposition?
Well, Your Honor, I could cite your own decision earlier this year, along with Justices Hand and Brennan, issued a Rule 128 decision in Wells Fargo v. Calagaris, 103 Mass App Court 1122, where the borrower had challenged compliance with this same regulation. There, the letters had been sent first-class mail, return receipt requested, but Your Honor noted that the record did not include any green cards. There was no evidence from the Postal Service, and the borrower's affidavits denied receiving the letters. The panel concluded that the affidavits denying receipt does not undermine this evidence or support an inference that the letter was not sent, because HED regulations require proof that a letter was sent, not that it was received. Any dispute over evidence of receipt is immaterial. There, the lender had submitted an affidavit with a copy of the letter attesting to business records and the custom and practice of the business to send the letters that it had been generated. I would also point to the Massachusetts U.S. District Court decision in Donahue v. Fannie Mae, which was affirmed by the First Circuit, Thomas v. Carrington Mortgage Services, as well as the District of Rhode Island's decision, Dan Harry v. PNC Bank. All of those say that reject the contention that by the Postal Service means that the proof must come from the Postal Service. As Donahue v. Fannie Mae, as affirmed by the First Circuit, stated, federal courts have held that mortgagees may prove compliance with 203.604 by relying on proof of a business system of preparing and mailing letters in compliance with such a custom in the particular instance, along with a copy of the business letter coded with internal identification numbers, names, and descriptions.
So in Donahue, I need to look back at that Calagaris case because they're all really important to us as we hear them and decide them, and then we're old and we don't remember them anymore. Speaking for myself, my colleagues remember everything. In Donahue, there was a copy of the letter in evidence, or before the court, it wasn't evidence, but as part of the file, that showed a USPS tracking number on the face of the letter, if memory serves. So the court took that information along with information about business practices to conclude that it was, that the Postal Service had certified it as dispatched.
And Your Honor, the summary judgment record before the Superior Court, my brother's opposition at pages 14 and 15 did not dispute that the records contained tracking numbers. It was that no information was submitted by the Postal Service. All we had was CENLAR. And if you look at Record Appendix Volume 3, page 9, here we have the first page of this document, which was attested to by the affiant, includes a tracking number above the borrower's name and address. We also have at pages 12, I believe ended up getting redacted because, again, the number itself was not deemed relevant by the parties' dispute, but the certificate of mailing form includes an area where U.S. tracking number is identified. It includes the postage paid. The postage paid is the 49 cents for first-class mail. It also included a $3.45 charge. Now, attached to Exhibit I of the summary judgment record before the Superior Court was the then applicable 2018 USPS rate guide that set forth that $3.45 was the rate for certified mail not without a return receipt. I don't know why it was sent without a return receipt. Those are the facts that we have. And, you know, the Superior Court judge said, okay, I have postage paid. I believe this letter was sent. An affiant says the letter was sent. We have this postage. But I would have to speculate that the $3.45 was the certified mail price, even though the record included at Exhibit I, the rate guide. And he said, on the other hand, the borrower denies receiving the letter. Well, we know from the case law that denial of receipt is not sufficient.
Right, I don't want to talk about that right now. I want to get back to this tracking number. So you've pointed us to the tracking number on page 9 of volume 3 of the record appendix above the mortgagor's name is, and obviously we're not going to rely on what you say here because it's not in evidence, but do you maintain that the redacted column on the left of page 12 of that same volume of the record appendix, if that hadn't been redacted, would show that same string of numbers?
I don't believe it the entire string of numbers. I believe the USPS, because I believe some of these numbers are extraneous because it adds internal coding numbers on top of the tracking number. As I recall, my brother and I discussed during the 9C conference and everything else, we both plugged in the numbers in the documents. They had gone stale. We weren't able to confirm and submit something from the USPS, such as the proof of delivery. If you plug a number in within a year or two, you usually get it. When you're 5 years.
I think you're answering a different question. What you're saying is you couldn't track it on the Postal Service website because it's been too long.
Correct.
That's not what I was asking. What I'm asking is, I think, well, the reg says certified by the Postal Service as having been dispatched. The document that you have here from the Postal Service is this thing on page 12 of volume 3 of the record appendix, right?
That is not from the Postal Service. That is
Okay.
internally generated.
Okay.
By
So the
Sentinel.
thing you have from the Postal Service is this thing on page 14 of volume 3 of the record appendix,
Yes, and
Which-
that is the certificate of bulk mailing.
which identifies 8,638 letters that were mailed.
Correct.
That must have been a hefty postal bag. So is that all that you have from the Postal Service?
That is all I have from the Postal Service.
Do you
So-
contend that that is enough under the reg?
So, Your Honor, I would contend that when we look at the regulation, we see from Donahue, we see from Thomas Carrington Mortgage Service, that by the Postal Service doesn't mean that it has to be from the Postal Service. As dispatched doesn't mean that you have to show delivery. And then if you turn to the decision in Lakeview Loan Servicing v. Walcott Bar out of Florida, the court right there went into the regulation and analyzed and said, well, what does it mean to certify? And so there, the court held that to certify a letter has been dispatched generally means to confirm or attest to the prompt or speedy sending off of something. And the court, again, similar to Donahue and the other cases, said that it does not require certified mail receipt from the USPS. Here, I would say that, well, I believe the borrower simply saying disputed in response to the statement of facts about this being sent certified to her does not rise to the level of creating a genuine disputed fact. So one of our arguments is that the only evidence against the lender's sending of the certified mail was the borrower saying, disputed, and as this court has instructed in Green v's Zoning Board of Appeals of Southborough, merely responding disputed to a statement of fact does not give a genuine, dispute. It does not follow Superior Court Rule 9A53. So on the one hand, I would say that the plaintiff did not properly dispute at summary judgment whether or not this was sent certified. In the alternative, I would also argue that if the word certify means to certify that something was sent off, we have the business records, and the Superior Court did hold that this letter, and however it was mailed, this letter was mailed. So if the Superior Court determines that the letter was mailed, that should be sufficient. I understand that the language of the regulation is a bit difficult, but time and time again we see that this statute is actually not interpreted, or this regulation is not interpreted rigidly. For instance, the regulation also reads that the mortgagee must have this face-to-face interview or make a reasonable effort before 3 full monthly installments due on the mortgage are unpaid. Now that issue of before 3, that seems pretty clear. It has to happen, has to happen before 3 monthly installments are missed. However, the courts that have looked at this have all said, no, it doesn't need to be 3 months. Donahue said that. Grimaldi out of the District of Rhode Island, which is at 2018 Westlaw 1997277, involved 5 years later a visit to the property, 5 years after default. Beam v. Caliber Home Loans out of Northern District of Texas at 2021 Westlaw 4445351. They've all rejected this must occur within 3 months, even though that's what the language says. Likewise, when we turn to this, how do we send? Well, one letter sent to the mortgagor. That was established by the Superior Court. One letter was sent to the mortgagor. So now we're back to this certified by the Postal Service as having been dispatched. Case law tells us it doesn't need to be by the Postal Service. Case law tells us it doesn't need to be dispatched, or it needs to be sent but not delivered.
So do you have a case that stands, what is your best case for the proposition that it doesn't need to be certified by the Postal Service?
So I would say that the interpretation of to certify from the Lakeview Loan Servicing case supports that. And going to the prejudice argument, so admittedly one of the difficulties of finding an analogous situation is because in a lot of states they do not interpret this regulation strictly, and the lack of prejudice ends up disposing of a lot of cases. So in Campbell v. Wells Fargo Bank, which is at 2016 Westlaw 6496458 at page 8, which is out of the Northern District of Georgia. That involved a case where it was determined that, I think the borrower even agreed, or it was factually determined that a first-class letter was sent providing the notice. The borrower disputed whether a certified mail was also sent. And the court said, well, the first-class mail might be enough. We're not sure we would read the statute, the regulation, as strictly requiring a certified mail, but we're going to dispose of this case for other reasons that the borrower's claims fails, including the fact that there are no damages because they didn't pay the mortgage. That's why they're in default. That's why the foreclosure happened. It would be futile to unwind a foreclosure years later based on this. So that's an example where, as here, the court had determined that a letter was sent. It had not determined that a certified letter has sent, but it disposed of the borrower's claims regardless.
All set.
Thank you, Your Honors.
Thank you very much. The panel has no further questions. I appreciate your arguments, and we'll take the case under advisement. Next case on our list is the Department of Children and Families versus Father and Another. This case is impounded, 2024-0413. Okay, so I see both the appellants and the appellees are splitting their time. So if I am reading this correctly, you have 7.5 minutes for your argument?
Yes, Your Honor.
Okay, great. Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the Court. Victoria Erin Carboni on behalf of the appellant mother. In this case, a mistake made by mother overshadowed her consistent engagement in services, her progress, and her positive interactions with her children, which was demonstrative of her bond with them. As a result, the trial judge wrongly concluded that mother's unfitness was permanent and terminated her parental rights. And then further, the judge did not order post-termination or post-adoption contact. I intend to argue 3 points. First, that it was an abuse of discretion to find that mother's unfitness would continue indefinitely into the future and to terminate her parental rights as a result. Second, it was an error to draw an adverse inference against mother regarding her absence on the second day of trial, as there was no conclusive record evidence of that absence. And third, that it was an abuse of discretion to fail to order that post-termination and post-adoption contact. In concluding that mother's unfitness was not temporary, the judge minimized and ignored mother's progress with respect to her engagement in services, including her continued engagement in services at the time of trial. One of the department's primary concerns in this case was the relationship between the parents. There was a history of domestic violence that led to the department's initial involvement prior to the removal of the children, of the 2 older children in 2019, and at that time. In particular, the department was particularly concerned with mother's lack of forthrightness, her failure to be forthcoming about re-entering her relationship with father. I would note that mother did testify that she had re-entered a relationship with father during a period of time that she had previously told the department she was no longer in a relationship with him. That was around 2019 to 2021. She also testified that she, or I'll take a step back. So she did testify to that effect. She did own up to that, and she did disclose that fact to the department while the case was ongoing. I would note that also during this time frame, mother was still continuously engaged in services. She completed at least 3, if I'm remembering the record correctly, domestic violence groups. She was engaged with an ongoing therapy, continued to do so at trial. She did also testify at Record Appendix 868 to 869 that she was open and honest in those groups and with her therapist regarding her relationship with father. So mother does recognize that she was not initially forthcoming with the department, but again, she did own up to that fact while the case was pending as well as at trial. She did not deny that. Further, she continued to engage in services, and finally, she was not with father by the end of trial. I would note also that from my assessment of the record that was before the juvenile court, the last incident of domestic violence between the parties, even during this period of, say, a re-engagement or re-entering into the relationship, I believe was in 2019. So trial started at the end of 22. So there was a long period where there was no record evidence of any domestic violence between the parents. I would note further that the judge's findings indicate that, in conclusions, indicate a failure to give mother due credit for her engagement in services and in her progress. She did complete almost all action tasks, or the tasks in her action plan. I think there was one that the department had alleged she hadn't completed, which was a parenting assessment, which the judge explicitly found was not actually a task on her action plan. And I think that was at finding 107. Additionally, during the case, mother attended all foster care reviews. There was testimony from the department that she did consistently engage in services and was doing so at the time of trial. Mother testified to that fact as well, that she was still continuing to engage with her therapist at the time of trial. With respect to the erroneous findings, as argued in my brief, these findings concern mother's engagement with services. The first is finding 106, where the judge found that the mother admitted at trial that she was not open and honest about her relationship with father. That's contrary to her testimony. Her testimony was, in fact, that she did tell her therapist that while she was meeting with her. So the finding that the mother had admitted to the contrary is clearly erroneous. I don't think this is an issue, as I believe the department argues in their brief, about crediting mother's testimony. The finding in and of itself that mother admitted to that fact is erroneous. And I think it further supports mother's argument that the judge didn't give her due credit for her full engagement in services during the pendency of the case. That goes to the finding, the clearly erroneous finding 99, which also concerns her engagement in services, that even while mother was engaged in this, had re-entered the relationship with father, that she wasn't engaging in those services to address the department's underlying concerns, which is contrary to the record. Regarding the second issue, the adverse inference, again, this error provides further support for the judge's conclusion that mother's unfitness was not temporary. There was a finding or I think it's a conclusion of law, actually, 20, that the mother was absent at 2 days. One was not a trial day, and then the second was the second day of trial. But the record evidence is not conclusive as to her absence. In fact, because there's 2 dockets here, so the cases were consolidated. There's one petition with 2 older children. The other petition is with the youngest child. And in one of the dockets for the 2 older children, there's a docket entry indicating that mother was not present that day, and that's at Record Appendix 26. And then in the other docket concerning the youngest child, at Record Appendix 66, it indicates that mother was present. Further looking at the trial testimony or the trial transcripts at on that day, the second day of trial, at Record Appendix 625 to 627, there was much discussion about father's absence that day at trial. Mother's absence was not mentioned whatsoever. So to think that, if one of the parents is absent and there's this protracted discussion about that absence, it would come up that the other parent was not there. So that clear error prejudiced mother and provided further support for the judge's conclusion that her unfitness was not permanent. As for the final issue, I'm running out of time, but I would just note that, again, there was evidence that mother's visits with the children were consistent. They were never terminated. She did see the children consistently. And with respect to the oldest child who had very severe behavioral issues, I think that an order an order for post-termination and post-adoption contact, in particular for that child, would have been important given the judge's explicit findings about the trauma that child suffered as a result of the removal, and given the fact that he had, I believe, 13 placements. Such an order would have helped him transition into a permanent placement. And with that, Your Honors, I would rest on my brief. Thank you.
Thank you very much. Counselor?
Members of the panel, may it please the court. My name is Jeremy Robin. I represent the appellant father here. Let me begin by saying, though we would all agree, it bears repeating and reflecting on how solemn and final a decree terminating parental rights is. It ends the natural order of things. It goes contrary to the natural order of things. It runs contrary to constitutional rights of parents to parent their children, and it must and is stintingly applied in only the most extreme instances where a parent shows no reasonable likelihood of being fit at some point in the future. And that's the only issue that the father is here appealing. That's not the case here. The father is not perfect. He said and done things that have been regrettable at times, but it's important to look at it through the prism of his life and his childhood. And he was the product of physical and sexual abuse in the child welfare system. So it should come as no surprise to anyone, not the DCF, not the trial court, not Your Honors, not myself, why he has some skepticism, some distrust toward the DCF. And he's acted in accordance with that skepticism at times and said and done things, as they say, that have been regretful. He also is afflicted with mild retardation. He has ADHD, bipolar, therefore has at times struggled with his ability to moderate his behavior and to refrain from expressing himself appropriately to the DCF. And it's also true that father did disengage from services for a period of time, 22 months, November 2019 to September 2021. But what's important here, I think, is that unlike a lot of the parents that we see in these state intervention child welfare cases, who disengage at the beginning and then it becomes a pattern, a worsening pattern, he didn't do that. He, in fact, did engage in services. The Batterers Intervention Program at STAR with someone named Dan Buckley, who notably raved about the father as an asset to the group. And isn't that what we're looking for in these cases, to ascertain whether a parent will have parental fitness in the future? Do they engage? What do they do when there's some adversity? What do they do when they're thrown in a situation where their children are taken away? And we've all seen that. He engaged in the nurturing parenting class through Arbor Counseling, Parenting Journey. He had therapy with Lane Briggs. When he did have visits with his children, he was appropriate. He was loving. They enjoyed the time that they had with him. And I'm taking an excerpt here from Record Appendix 465 that he, quote, took a photo after asking staff, set appropriate boundaries, consoled his children when the visit ended, showed proper affection. Isn't that the type of thing that we're looking for when we make the calculus of whether maybe a currently unfit parent is at the time? Will this parent be able to potentially be fit in the future before we take this extreme step of terminating parental rights? So let me say then in sum, while the father acknowledges, concedes his current parental unfitness at the time of trial, given what he showed as an engagement in services, there was a reasonable likelihood that his unfitness would be temporary, and we ask that the termination of parental rights decree be vacated. Thank you very much.
May it please the court, Richard Salcedo for the Appellee Department of Children and Families. Your Honors, the department is asking this court to affirm the trial court's decision finding mother and father unfit and terminating their parental rights. In making its decision, the court issued 155 or 152 findings of fact based on the evidence presented, including mother's testimony, and those findings of fact taken together clearly, convincingly support the trial court's decision. Wanted to just highlight the history a bit in this case. I know your honors are familiar with the facts, but this case became involved, or the department became involved in the case due to serious history of domestic violence involving these parents. When they had the opportunity to parent their children, the father, by mother's own reporting, kicked, punched, slapped, and choked her. There were, over a period of time, 6 different police responses to the home. There were a series of 51A and 51B reports involving this family, and the oldest subject child was exposed to, at least in one incident, of physical violence in the home. That same child was also exposed to pornography while the child was residing in the home. Despite this history, mother minimized the violence that had occurred. She declined to obtain a 209 order of protection from father, and she resisted department efforts to safety plan, to make efforts to keep the children and her safe. And continually, she engaged with father. And during the course of the case, she intentionally deceived the department over a 2-year period. She told the department she was no longer talking with father, not in a relationship with him, and had not heard from him. But as we learned later, she was in fact with him the entire time. In December of 2021, the couple had their 3rd child, which is the youngest subject child. That was in December of 2021. And in July of 2022, which is right before, the year before trial began in 2023, there was the incident where father exposed himself to a teenage girl who he had coerced into meeting with him under the pretense of hiring her as a nanny for the family. And what the evidence shows is that mother was present during this incident. Father was arrested and charged with indecent exposure. That was in July of 2022. Although mother has engaged in services during the case, as the evidence indicates, and the court did not ignore mother's efforts. The court, as we detail in the department's brief, does credit mother for engaging in services during the case, but mere cooperation in services does not render a parent fit without appreciable evidence that they are taking or making efforts to meet the needs of their children. And what the court concluded based on the history of the case, based on mother's testimony as well, is that mother continued to have contact with father. She testified that he had moved to Chicago, had taken a trucking job, but she could provide no details about the company, where she was living or anything else. And the court specifically did not credit her testimony and found that they in fact continue to have a relationship. So based on all of that evidence.
Do you have a position, sorry, on the mother's contention that the finding about the length of time, that's a terrible question. The mother says that the judge erred in saying that it was from 2018 to 2021 that the mother misrepresented to the DCF worker that she and the father were not together. And that actually the beginning date, that social worker didn't start until 2019, and so there was like a 1-year swing there. Do you agree that that was a mistake by the trial judge, or at least not supported by the evidence?
I think it was perhaps a mistake in the timeline exactly, but what the evidence does show, whether it was that social worker or another social worker, the evidence is pretty clear that mother continued to have a relationship with father throughout, and pretty much from the beginning. 2018, I would say, is accurate. Whether it was from that social worker's testimony or some other evidence, I think the evidence does support a continuing relationship with mother and father.
And with respect to the situation that was current at the time of trial, do I understand the last thing you were saying before I interrupted you to be that although the mother presented as fact that the father was no longer around, that the department hadn't corroborated that and that the judge didn't credit it?
The department did not present any evidence, in fact, that the parents were together. But I think mother's testimony at trial, that they were because she had made the same claims throughout to the department that they're no longer together, which is what she was testifying to at trial. But there was no proof that, in fact, he was no longer in the home. I don't know other evidence that was presented that the department could show that he, in fact, was. But the trial judge did specifically find the mother's claims were not credible.
Did mother miss a day of trial?
The record does not show that she was there that day, so I think the record arguably supports that she was not there on that particular day. I don't think it was a major factor in the court's decision, but I think it is supported by the record. Unless there are any other questions, I'll rest my brief.
No.
Thank you.
Thank you, Counselor.
Hi, may it please the court, my name is Alessandra Donovan and I represent the 3 minor children. Some of the issues that were apparent the day of the removal were consistently there for the 6 years that this case was open. And honesty was one of them. Who was with whom where when they removed the children. They were not supposed to be at the home. They were supposed to be somewhere else. They lied about that. Domestic violence, as we heard. Father's aggression and threats. Lack of cooperation. And the parents had 6 years to cure all this, and they did not. I want to start with honesty. At some point, it doesn't matter whether it was a trial or with DCF or whatever, at some point, mom was saying one thing and then she would say another one. She said at least from 2019 to 2021 that she was not with father, and on the contrary, she was. And at one point, she was telling DCF that they were not together, and at the same time, father was at the DCF office telling DCF, yes, I've seen the children, I've been there. Why this is important is because it falls into the domestic violence part. They were contradictory in the type how their domestic violence was. Mom was saying that she was not afraid of him, that nothing really happened, and nothing really happened before the very first episode that we know of in 2017, whereas father said, no, there were cases before. I want to address the fact that mom said that the abuse ended in 2019, but she also said that father continued to be verbally abusive and supposedly controlling as well. Namely, he was paying for things. She could not have a phone. She could not take the bus by herself. There's a whole list indicated in the findings. One of the goals in mom was to understand the effects of domestic violence on her and the children, and the fact that mom kept denying that father was living with them I think it's a point. It's an example of her parental incapacity. the judge at the trial level can make a determination of parental unfitness when the victim decides to keep living with her abuser. And also, in Carla, the parent's willingness to ignore and minimize abusive behavior can be an indicator of unfitness, and we saw that in this case. But violence was not just domestic. I mean, father was aggressive with DCF. There's a lot of, in the findings, we see that father was combative around the children. It's not true that at the visits it was all lovey-dovey. He slammed his fists on the table. He used really inappropriate language. He was aggressive during visits at DCF with telephone calls with DCF, emails. And in one of the emails, he hoped they all die in a fiery pit. And then we're talking about engagement. In Rona, the court held that a parent's refusal to cooperate with the department, including failure to maintain service plans, is relevant to determination of unfitness. So here, father disappeared for 2 years. He was not engaged. Contrary to what father claims, his engagement with providers was minimal. There is evidence in the findings that he barely engaged with his therapist, and he never really did the abusive intimate partner assessment, and he only did 6 sections with the program. And he also said specifically, and I'm not going to quote the language here, but in very pointed language, he said he didn't have to do that. And so in other words, he never owned up to the fact that there was domestic violence in the relationship. Mother was cooperative with DCF and consistent attending therapy, but from what we saw in her, what she did and she did not do, that she was not internalizing what she was learning or what was talked about in therapy. And if she was lying to the therapist, and then maybe not lying, we don't know what happened there, but she was definitely not learning how to make a safe home for the children. And she also did not meet with DCF. She disappeared from October to December 2022. And we know that the judge at the trial level can look at the lack of engagement in services to support unfitness. But even if both did comply with the action plan, the mere participation in services does not render parent fit. It's what you learn from it, how you demonstrate that you can do what you learned. And contrary to what the parents said, the court did not just do a cursory analysis, but was very specific in the instances in which parents that lied, were aggressive, did not participate, etc. And because I'm running out of time, I just want to put things in perspective. The boy was removed when he was 3.5 and he's now 8. The oldest girl was 2 months old and she's now just turned 6 years old. And the youngest girl was just a few days old and just turned 3 years old. They've been in foster care most of their lives. And they are now, since June, the oldest boy has been placed in a pre-adoptive home, and since October 23, the girls. I think that the fact that there were a lot of placements is it's a red herring, as the red herring of mother being or not being in court that day. The children were supported termination at trial and keep their position now. And sibling contact is already happening, and the parents, the pre-adoptive parents, if they become the adoptive parents, should have the discretion of whether visit and how they should happen when and if they're in the best interest of the children. Thank you.
Thank you very much. Thank you, all 4 of you. These cases are always very difficult and pose difficult problems. We'll take the case under advisement. Thank you for your arguments. That brings us to the last case on our schedule for today, which is in the matter of a minor, 2023-1486. And this case is also partially impounded. Good afternoon.
Justice Funo, Singh, Hirschfang. Good afternoon. My name is Sandy Derlin, and I represent the appellants, the paternal grandparents in this matter. Unless the court has any questions, I'll just make some brief comments. This appeal is not about mom's fitness. There was ample evidence at the trial, most of which was credited by the trial judge, that spoke to the changes that the mother had made in her life since the guardianship was implemented 7 years prior to the trial, the final trial occurring in this case. There certainly was evidence of her stability and her employment and her efforts to treat prior drug abuse or drug addiction. And the evidence showed she was in a committed relationship and had another child, none of which is challenged by the appellants in this case. But that finding of fitness, while supported, does not end the inquiry. That leads to the challenge.
I'd like you to respond to this sentence from this court's decision in Guardianship of Estelle, in which Justice Cowan wrote, "Custody of a child belongs to a parent unless that parent is unfit." And you've just started your argument by saying that your clients are not contending that the mother here is unfit.
Well,
so how do those two things go together?
No, I mean, there is a distinction, and the distinction is fitness can be present for one child and not present for the other. And I think here, this child, who is the subject of these proceedings, the findings and the evidence, I do not believe, showed sufficiently that fitness inured or flowed to this child. That's the distinction.
So the mother is fit to parent the younger half-sibling in your client's view, but not this child?
I can't speak to whether she's fit. And I don't think my clients or even the evidence show. I mean, the reality is that child was not at issue. The issue is whether the findings and evidence supported that the revocation of the guardianship was in the child's best interest, even in the face of mom showing an ability or a fitness, if you will.
So the guardianship in this case was temporary, right? I understand it was temporary for a very long time. It kept being extended and extended. What is your best case to support the proposition that a temporary guardianship, which by its nature will expire, must be terminated? There must be some showing to terminate it.
Well, I think...
Is that a bad question? I can try again.
No. Hesitation doesn't mean... I mean, the reality is, I think Chapter 190B, Section 5-212A, I think indicates that when you're revoking the guardianship, albeit a temporary guardianship in this case...
But it doesn't say that, does it? I don't have it in front of me anymore, but my memory is that I read it, and it doesn't seem to speak to temporary guardianship.
Well, I'm not going to sit here and speculate or misstate. I mean, my interpretation of the statute speaks to the guardianship as a whole, and in this case, the length of time that this child was under temporary guardianship speaks to the need for the judge to address the revocation in the manner I just suggested. And here, I contend that the evidence, both the evidence and then the resulting findings, don't support that conclusion, or in the absence of the evidence, whether the judge should have then taken remedial measures in the face of eventually terminating the temporary guardianship and returning the child to the biological mother. You have a number of cursory findings in this case, which I believe are problematic and not supported either by the evidence or by subsidiary findings. And that speaks to her ability to be fit to parent this child, that the best interest for the child is to have the mother, the biological mother, have sole legal and physical custody, that she was capable of meeting the child's safety, medical, academic, and emotional needs, all of which were found by the judge, but only in cursory fashion, and I don't think that the evidence supported it. And that's where this is deficient.
So, counsel, I think I need to clarify your position, because I thought you were, in your briefing, you claimed that you weren't challenging fitness. But now it sounds like you're saying you are challenging fitness.
No. The distinction is when, in this context, there is both a need to find that the parent is fit and that the revocation of the guardianship in the face of that finding of fitness is in the child's best interest. And that can result in a dichotomy where you have fitness, generally speaking, but not fit to parent this child. That's the distinction. And that is, and cases for many years have talked about that. And that is the distinction here. And the problem, I dare say, is that the evidence and the findings don't necessarily sync with the ultimate conclusion that mother is fit and that it is in the best interest of this child to be returned to her. That's the difference. And here, the second prong, or that second part of that analysis, was deficient. And I think a fair reading of both the findings and the evidence don't support that conclusion. And the findings don't give enough detail to explain how the judge drew that conclusion. And that's the problem. You know, for example, you have evidence that mother had a history of instability. There was a cognitive disorder, apparently a diagnosis of some cognitive disorder, and evidence of a deficiency processing complex information. This child, the evidence showed, this child has very complex personal, academic, and emotional needs. And here, both the guardian ad litem and the child's therapist expressed concerns over whether mother was capable of addressing those for that child. That was not addressed by the judge at all, except, again, in the most cursory fashion. The same is true for...
well, the judge did make some detailed findings with respect to the mother's current situation in terms of her employment, her housing stability, her personal relationship stability, the fact that she was parenting without any issues, another child. There was a bond between the two children. There was findings specifically with respect.
I don't dispute that, Your Honor. But here, what you have, there was evidence of, as I said, complex needs of this child. In the period leading up to the trial, there was evidence of the mother not making appointments, not attending to scheduled activities, that sort of thing. There was, with respect to her prior drug addiction, I mean, she failed a drug test at the beginning of the first trial in this case, all of which, it's not a question of demeaning the mother's efforts. They were laudable, and they were certainly credited by the judge, but there wasn't that connection, that synchronicity, if you will, with this child, and the concerns raised on sort of an objective basis by neutrals seem to have been sort of swept by the judge. Now, the judge is not required to be bound by the guardian. The judge isn't required to be bound by, what the child's therapist said. But in the face of that information, and the judge noted all of that in her findings, but she didn't then explain how, given those concerns, whether she was discounting them, finding them not credible, or how mother would then address them going forward. And that speaks to sort of the second part of my argument, and that is, to the extent that the evidence did not necessarily support a finding that mother is fit to parent this child, the judge could have done other remedial measures on an interim basis to assure that this child's needs and best interests were protected. And I allude to them in the brief, requiring continued therapy, continued drug testing, and so forth. Those are the sorts of things that were available to the judge what I think, in the absence of some evidence as to sort of a future plan, which would have then allowed for both the child's needs to continue to be met, as well as segueing to the ultimate result in this case at a future date after some proven ability to meet this child's needs. So the issue is twofold, and that is, I don't think the evidence and findings on that fitness question were met, and I don't think the findings supported it. So unless your honors have any other questions, I don't need to belabor the point. Thank you.
I see none. Thank you very much for your argument. Counselor?
Good afternoon. Mark Belrose for the appellee. I was also trial counsel for the mother, Jenna nephew. I heard this court make sports metaphors earlier today, and I got all excited at those metaphors, and I'll use one myself. As the great 20th century philosopher Mike Tyson once said, everybody has a plan until you get punched in the mouth. And so I had a list of things that I was going to address, and having heard my brother counsel make his arguments, I find that I'm going to modify my argument. I'd first point out, as a practitioner, and I don't mean to be critical of Attorney Derland, I know he practices in the family law area as well. There is great confusion amongst family law practitioners about the connected cognate standard of fitness and best interests of the child. So I'm not certain how Attorney Derland could make the argument that the judge's findings are not supported and ignore the fitness standard. In fact, I think he's referenced it several times. So just as a point of clarification, I think it is intended to be a single standard, and I'll explain in a second why I don't think it can be in practice, Your Honor. First, I would point out that, as Justice Hirschfang pointed out, there's a question about the temporary nature of the guardianship. And I think that's important for several reasons, but most importantly, primarily, it means that the petitioners have the burden of proof to show that my client was unfit at the time of trial. That certainly isn't a single snapshot of her fitness, and I think this plays off of Justice Bono's point as well about the current findings of her fitness at the time of trial. I would correct that slightly, Your Honor. The judge entered findings, for example, with regard to my client's criminal history. There was a single incident in January of 2016, which led to criminal charges in New Hampshire. There's a reference by Attorney Derland in his brief that those charges, the criminal charges, were cleared up by 2023. That's accurate as far as it goes, but what would be more accurate to say is that there were no incidents of conduct on my client's part since January of 2016 to the time of the conclusion of the trial in May of 2023 involving her with the criminal system at all. So it isn't simply a snapshot of her not being engaged in criminal activity in 2023. There's no evidence of any such criminal activity since January of 2016. Similarly, with her history of substance abuse, Your Honor, I would correct something that Attorney Derland said regarding a positive test in a moment, but the judge's findings don't just specifically refer to her sobriety at the time of the trial. In fact, the judge found that my client had not imbibed in or consumed any illicit drugs since 2011. During a period of 5 years, from 2011 to 2016, she was prescribed Suboxone, which is essentially an opiate substitute to help her with her addiction. But there were no illicit drugs taken during that period of time. And from 2016 to 2023, she underwent, by her estimate, over 100 drug tests through the probation department of the probate and family court, all of which were negative. There was one case in 2018 where she was unable to produce a sample. And what she did, upon my advice, after having been able to do that, she went and took a hair follicle test, which was also introduced at time of trial. That was negative. When the probation department concluded its investigation of her sobriety through the testing procedure, she voluntarily took hair follicle and nail file tests through 2023. There was not a month from 2016 to 2023 where she did not have coverage of some test or another, whether it's a urinalysis, hair follicle test, or even the longer prospective test of the retroactive test, rather, of the nails. So in those two cases where there were concerns, as raised by my brother counsel in his memorandum about my client's ability to remain sober and continue along that same path, that's always a question that is asked in any case where somebody has a history of substance abuse. And the fact that somebody has a history of substance abuse does not per se mean that they're not fit to care for their child. What the evidence also shows, and was included in the judge's findings, is that my client was engaged with the psychiatrist during the period of time from 2016 to 2023. She had a psychotherapist during that period of time. She attended NA meetings. She had in addition to the test that she took through the court and voluntarily, she had a job which included periodic random screens. They were only initiated in the event that she was behaving in a manner that would cause a manager to be concerned about her sobriety at the time, but she was never had to engage in any of those tests. She also engaged with the New Hampshire, essentially their DCF. She was a parent who volunteered her time to work with other families who were in the system, and that was asked of her by one of the local providers. So I think there's ample evidence that she's proven, as far as her quote-unquote personal defects, that she's improved. There's been a trajectory of improvement, and it's been consistent for, at this point, almost a decade.
So I note that the date on the findings from the probate and family court is now a year and a half ago. May I ask, is your client here with you today?
She is.
Okay.
She's in the gallery.
And good afternoon, good morning, good afternoon. Is the child living with her now?
Yes, the child's been living with her since the entry of the judgment, and so that goes to the issue of the best interest standard. And I think, honestly, there's been a disservice of sorts with the term best interest of the children, and it's caused some confusions. There really are two separate standards when it comes to best interest, and I refer to, I believe it's Guardianship of Estelle, and there's a specific statement in Guardianship of Estelle that says just because there's a alternate caretaker who may be more qualified, or whatever terminology is used, and maybe they're 5% better at taking care of a child's medical issues, that doesn't mean that the parent should lose custody of that child. So if other cases where it's a parent-to-parent and the fair fight is occurring, something that the court could not consider competence, for example, degrees of competence in a guardianship case, they could consider in a divorce case or a modification case. They do compare equals in the case of two parents, where they are not equal in the case of a guardianship case or a termination case. You have to look at the standard of the parent and compare that person individually. Are they fit? There are some considerations to be taken when it comes to their ability, when it comes to fitness of that particular child. And what I would note in that respect, contrary to the Guardianship of Estelle as well, my client did not forego her parental responsibilities, as did the father in that case, in which the judge found that he was content to let the grandparents do all the heavy lifting while he was the weekend dad, as we say in family court. She has been involved, or was involved, with the child's pediatrician from 2016 through 2023. She was involved with the child's specialized care at Children's Hospital from 2016 to 2023. She had regular meetings with the child's therapist, with the school providers, teachers, and guidance counselors from 2016 to 2023. Prior to that time, the child was what's termed, I believe, a micropreemie. So she was in the hospital for 3 months without any assistance at all. I believe that the grandparents appeared once at the hospital during that period of time that the evidence at trial showed. So she was exclusively responsible for the care of the child. And then in 2016, admittedly, she suffered a crisis. The family that she thought she was going to have, she didn't have. She had an abusive, quote-unquote, father, husband rather, father of the child. The judge found that he was abusive. He has had no involvement with the child since then. And in fact, part of the best interest standards, if you're looking at what's best for the child, the judge concluded that the child has what we would call euphemistically an intact family right now. He has had a relationship with my client's fiancée since 2016, where she has lived for the last 7 years up to the time of the trial. He has a brother, a younger brother. There was evidence taken at the time of the trial regarding their relationship, the quality, nature of their relationship. Apparently the child has great interest in being the big brother. I'm the oldest, and I wasn't always happy about that rank in the hierarchy. But in any event, Your Honors, there is more than sufficient evidence to show that my client is both fit at the time of the trial, and there's a history of fitness. Also, there's sufficient evidence to show that it is in the child's best interest that he be placed with her in her family. One of the last things I'll say on a final negative comment, there is case law when there's a comparison of parents. The question is, which of the parents is more willing or able to foster a relationship between the children and the other parent? And in this case, there's evidence, including statements by the GL in her final report, that it was clear that the paternal grandparents were, in fact, a negative influence on the relationship between my client and the child, whereas my client testified as to what she would be doing if the child was placed back in her care. I'd note also, Your Honors, that there is really a second best interest analysis that was conducted by the court, not just relative vis-a-vis my client and the child, but the grandparents filed the grandparent petition, and that's also one of the areas where the best interest standard comes up again. Slightly different than the parent-to-parent, but the judge made it a determination that it was in the best interest of the child that there be a grandparent visitation plan, which was more or less consistent with what the father would have if he was competent. So there was an acknowledgement of the transitionary period that would take place and the difficulty the child may have, and as a consequence, because of the relationship between the grandparents and the child, the judge put in a very detailed plan in place. And
is that still in practice?
It is in practice. One of the things that was a bit of a concern, at least raised by the grandparents, is that my client lives in a different state than where the trial was conducted. But they're literally in adjacent towns. The grandparents live in Pepperell, and my client lives in Nashua. And so it really isn't a very long ride. I mean, there are places in Massachusetts would be much further than the distance between them.
You had mentioned that you were going to address issues about cognitive issues.
Sorry?
I believe you had stated earlier that you wanted to say something addressing concerns about cognitive issues.
Oh, about my client's cognitive
I'm not sure I heard
issues.
that.
Yes, in fact, there was a guardian ad litem, a Category E guardian ad litem, who was appointed for the purpose of conducting a psychological evaluation of both parents. And he had access to information regarding both parents' criminal and alcohol and drug histories, and access to their records from treatment providers. And he concluded, and this is part of the judge's findings, that there was no deficit that he found that would prevent my client from being a proper parent. Unless you have any further questions, I have nothing further to say.
I see no further questions. No, thank you both very much for your arguments.
Thank you for your time
Appreciate it.
today.
All right, that concludes our arguments for today, so the court will stand in recess.